My lord, I may be pardoned to mention, my lord.
1 minute. Judgment. For judgment, item number 1, CRA 81 of 2001.
The appeal is dismissed. Bail bonds, the appellants are cancelled. They are directed to surrender not later than first office.
For judgment, item number 2, WPC 17546 of 2011.
The writ petition.
TREV 13 of 2001.
None appears. Dismissal not possible.
Weekly list old matter item number 2.
None appears. Dismissal not possible.
Weekly list old matter item number 3.
Not pressed, my lord.
Counsel, the
Question of
petitioner
law
states he is not
left over, my lord.
All right.
My lord.
Dismissed as next.
Weekly list old matter item number 4.
None appears. Dismissal not possible.
Weekly list item number 5.
No instruction. No instructions. Dismissal.
Weekly list item number 6.
May I please? The question that has been referred to your lordship for determination, it is page 5, whether in the facts and in the circumstances of the case, paddy seeds, maize seeds, wheat seeds are cereals within the ambit of section 14 of the CST Act, and therefore the rate of tax under the State Act shall not exceed 4% in view of the restriction and condition imposed in section 15 of the CST Act. In fact, my lord, a similar question has been answered by Honorable Patna High Court and Guwahati High Court in favor of the department, my lord. Sir, no notice is even gone in this. For 21 years, no notice has gone. was listed, my lord, on various occasions, but as my record shows, it didn't reach.
Paper books have been prepared. This is a 1995 case which got renumbered as 2001 tax revision case.
Yes.
But in fact, this question is no more recently granted. Many of the honorable high courts have answered it in.
All right, and then we leave it at that. Just say this revision petition arises out of. In fact, there were two SJC's numbers, then merged into one, I think. This revision petition arose from an order dated 31st March 1995, passed by the Orissa Sales Tax Tribunal in the essay number 586-587 of 1988-89. For the year 1983-84, holding that paddy seeds, maize seeds, and wheat seeds are to be subjected to sales tax at 4%. On par with rice, maize, and wheat, which are declared goods under the Central Sales Tax Act. Bracket CST Act. Paragraph. Thereafter, on applications being made by the state under Section 24, bracket 1 of the Orissa Sales Tax Act, 1947, OST Act, the tribunal, by an order dated 23rd September 1995, stated a case to this court and referred the following question to this court for its opinion. A to A. Initially, the references were numbered as SJC numbers 165 and 166 of 1995, and subsequently got renumbered, got merged and renumbered into one case, namely TREV 118 of 2001 Stop. The last order passed in this case was on 5th September 2001. Where some correction to the actual numbering of the case was asked to be carried out by the Deputy Registrar, judicial of the court, paragraph. For 21 years now, the case has not been listed thereafter. As a result, no notice went to the other opposite party at all in all these 21 years. As far as the question itself is concerned, there are decisions of the Patna High Court in Messrs. SPI CPHI Seeds Limited was the state of Bihar, 2005 142 STC 241 bracket Patna bracket, as well as the decision of the Guwahati High Court in Assam Seeds Corporation Limited versus Commissioner of Taxes Assam, 2006 145 STC 245, both holding that seeds are distinct from cereals and cannot be treated as cereals for the purposes of tax, for the purposes of sales tax. So, therefore, the aforementioned question referred to this court for its opinion has to be answered in the negative, that is in favor of the department and against the SSC. Paragraph. Considering that the SSC has not been issued notice in all these 20 years, and the court does not propose to do so at this stage, particularly with there being no interim order in the meanwhile. While answering the question as above, the court directs that vis-a-vis the SSC, no further steps need to be taken. The petition is disposed of.
Weekly list item number 7.
None appears dismissed now.
Weekly list item number 8.
8 appearing for OP2, my lord.
None appears dismissed now. Yes.
Weekly list item number 9.
We have not carried out the.
Yes, no steps have been taken for show cause notice to be issued to the opposite party with correct address.
Weekly list item number 10.
Consequently, the petition is dismissed from office.
Item 10.
10 and 11, the files are missing with us.
All right. Counsel for the state informs the court that the paper books are missing. Petitions are dismissed with liberty to revive them in the case, in the event that the paper book is located.
In fact, 10, 11, 13, 14, similar.
Okay. 10, 11, 13.
Item number 12.
None appears dismissed from office.
Weekly list item number 15.
None appears dismissed from office.
Weekly list item 16.
Made, please, my lords. Am I audible, my lords?
Yes, yes.
My lords, I'm slightly under the weather, my lords, so I'm appearing virtually, my lords. Your lordship may pardon me for that. My lords, this is an application, my lords, arising out of the order of the Honorable Sales Tax Tribunal, where, my lords, the sales tax exemption under the Industrial Policy Resolution of 1989 has been denied, my lords, despite there being a certificate to that extent issued by the DIC. Matlab, this is
Covered.
square.
Yeah, covered.
Vadilal Chemicals, your lordships knows.
Right.
Vadilal Chemicals 2000.
Correct. All right. You say, while admitting this revision petition of the SSC against an order dated, you say arising from an order dated 31st October 2007 of the Orissa Sales Tax Tribunal in second appeal number 537/2007-6.
6-7. Sorry, my lords.
No, oblique 6-7 for the year 1998-1999 by an order dated 24th August 2012. This court framed the following questions for consideration. Paragraph. Having heard learned counsel of the parties, the court is of the view that both questions require to be answered in favor of the SSC and against the revenue. By virtue of the decision of this court, give us the copy of the decision.
Yes. The Honorable Supreme Court's judgment, my lords, is 2005.
Vadilal. That's
Yes,
it.
2005 6 SCC 292.
That's all discussed in this judgment. No. What about this court's judgment? There are so many judgments we have passed as a DB. Sir, there are so many judgments we have delivered. You have not seen any of them.
Let's those I'm slightly unwell.
Yes,
my lords.
3 or 4 judgments just in the last few months.
Yes,
You
my
I'll
have
give
it?
the reference. My lord. I'll give the reference.
All right.
I'll give.
In view of the decision of this court in dash versus dash, which in turn is referred to the decisions in Vadilal of the Supreme Court in Vadilal Chemicals Limited versus State of AP, 2005 6 SCC 292, and this court's earlier decision in the Induri Limited versus Commission of Sales Tax. No, not this. Not this Induri.
India Limited, my lords, is on a different issue.
Another point, yes. All right. In Navabharat Ferroalloys Limited versus State of Orissa, 2010 31 VST 319. The revision petitions according disposed of, the impugn order of the tribunal is hereby set aside.
Weekly list item number 17.
Right.
17, my lord, the question of law has been framed by the order dated 11th of February 2013.
But notice doesn't go to the other side. I don't know what system here we follow. How is the other side supposed to appear without notice?
My lord, notice has been issued on 11th February 2013.
11th February?
2013.
No such order at all.
Oh,
Give me a paper book. Ah.
The question of law is like this, my lord. Whether on the facts and in the circumstances of the case, the tribunal is justified in holding that there was ambiguity in Finance Department notification number so-and-so dated 31st March 2001 and required interpretation in favor of the dealer RCC, particularly when plain reading of the said notification would lead to understanding that the dealer manufacturer is entitled to claim set off of tax on purchase of raw materials separately indicated on the body of the bill invoice. Whether in the facts and the circumstances of the case, the tribunal acted with material illegality and beyond scope and authority of Rule 19 of the Orissa Entry Tax Rules. Whether on the facts and in the circumstances of the case, the Sales Tax Tribunal committed error by interfering with the view of the First Appellate Authority who has confirmed the order passed by the assessing authority on verification and examination of books of account, recording finding that claim of set-off of entry tax as made by the opposite party is untenable in as much as it could not produce the purchase invoice against purchase of raw materials. My lord.
So has he indicated the raw material separately in the bill of invoice? That's the only question.
Yes, my lord. In fact, if your lordship would kindly turn to page 25, that's the relevant portion of the order of the learned tribunal. There the note 1, my lord, may kindly see at the bottom. This note 1 is appended to the list C of the rate of tax chart. It says the amount of tax payable in respect of goods specified in serial number so and so, so and so. Admittedly, the dealer's goods is falling under these serial numbers. So and so shall be reduced by the amount of Orissa sales tax paid by the dealer on raw materials and consumables subject to tax on purchase turnover and or, this is important, tax collected from him by the selling dealer separately on the body of the bill in respect of sale of raw materials and consumables subject to tax on sale turnover directly used in manufacture of goods. Here, kindly mark the word and or tax collected from him by the selling dealer.
So para 9, come to para 9.
Yes. May place, as would be seen from the close reading of the above relevant provision in toto, that nowhere it is required that the bills issued by his seller of the appellant should reflect the sales tax liability on goods sold by them on the body of the bill. The provision of note 1 requires that the amount of tax payable in respect of specified goods shall be reduced by the amount of Orissa sales tax paid by the appellant on raw materials on consumables subject to tax on purchase turnover and or tax collected from it by the selling dealer separately on the body of the bill in respect of the sale of raw materials and consumables subject to tax on sale turnover directly used in manufacture of such goods. The word selling dealer in the provision cannot be construed to have been confined to the immediate seller of the appellant. No doubt in taxation law, though the provisions of the statute are to be construed strictly, it is well settled that the statute levying tax or duties upon the citizen cannot be extended by implication beyond clear import of the language used, nor can their operation be enlarged so as to embrace matters not specifically mentioned therein. No tax can be levied on any dealer unless the charging provision clearly imposes the obligation. The above principle is also applicable in the matter of exemption. Besides, it is not in dispute if the language of taxing provision is ambiguous or capable of more meanings than one, then the meaning favorable to the RCC is to be adopted. Further, the wordings provided in the statute should not be interpreted in piecemeal. Therefore, to our proposition, the term seller used in note 1 of list E of the red chart can be extended to seller's seller. That's where when the note 1 clearly says to the seller, now the honorable tribunal, by interpreting bringing out the theory of ambiguity, says the seller's seller. Actually, they're doing.
We say, while admitting this revision petition, it's directed against of the state, directed against an order dated 14 February 2011, passed by the Orissa Sales Tax Tribunal in essay number 240 bracket ET of 2004-05 for the year 2002-03. This court, by an order dated 11 February 2013, framed the following questions for consideration. Take from the order. Paragraph. The background facts are that the SSC paragraph, it may be noticed at the outset that despite, you say that when notice was issued to the opposite side, the service of such notice came back with the endorsement, single quotes refused. Stop, therefore, the opposite party should be taken to have been served. Stop, none appears for the opposite party. Paragraph. The background facts are that the SSC manufactures iron and steel goods and has obtained the benefit of a set-off of tax paid on raw materials in terms of notes 1 and 2 of list C of the rate chart notified under Section 5 of the Orissa Sales Tax Act, 1947, bracket OST Act. Paragraph. The case of the SSC was that it procured raw materials for the manufacture of iron and steel goods. Either by paying sales tax as the first point directly from a purchaser or from another registered seller who has in turn purchased the goods from on payment of first point tax. And advised the seller to consign the goods to its purchasers directly. Full stop. Paragraph. In some of the second category of transactions, the SSC purchased the goods from its seller without showing sales tax liability on the body of the bill issued by its sellers, who in turn purchased the goods from the Rourkela Steel Plant Rourkela on payment of first point tax, and advised the seller, bracket sale, to consign the goods directly to the SSC. Full stop. In both categories, the SSC claimed set off of the tax paid on raw materials. Paragraph. The sales tax officer, bracket STO, allowed benefit of the set off only on the transactions of the first category, that is, case of direct purchases from the sellers who collected tax at the first point of sale. Full stop. In the second category, the benefit was refused on the ground that the bills issued by the sellers did not reflect the amount of tax, open quotation, on the body of the bill collected from the appellant, unquote. Full stop. Paragraph. The SSC also claimed set off on the basis of straight jacket formula on payment of sales tax on raw materials against the sales tax due on the entire sale transaction for the finished goods in that financial year. Full stop. However, the STO allowed set off only in proportion to the sales tax paid on raw materials purchased and used in the production of finished goods in a particular year against the sales tax due on the sales transaction of the finished goods in that particular year. Paragraph. Thirdly, the STO acted on a fraud case report alleging purchase suppression of 9.290 metric ton of coal. Full stop. Not being satisfied with the SSC's explanation, the STO enhanced the gross turnover, bracket GTO, and taxable turnover, bracket TTO, by rupees 1 lakh on the basis of best judgment assessment and rejection of books of account. Paragraph. After the Assistant Commissioner of Sales Tax, bracket ACST, dismissed the SSC's appeal, the SSC went in further appeal before the tribunal. Paragraph. The tribunal appears to have accepted the contention of the SSC that, notwithstanding notes 1 and 2 in the of list C of the rate chart, requiring the payment of sales tax on raw materials to be shown separately in the body of the bill itself. The words open quotation, the selling dealer, unquote, would include not only the immediate selling dealer vis-a-vis the SSC, but any of the earlier selling dealers. Full stop. Consequently, it will tell that the SSC is entitled to the set off on the sales tax already paid on the purchase of raw materials. Paragraph. On the second issue also, the tribunal held in favor of the SSC. By holding that the provision does not suggest that raw materials not used in production in that financial year are not qualified for the purpose of set-off. Full stop. According to the tribunal, open quotation, the only meaning emerging from the provision is that set-off is to be calculated on the basis of sales tax paid on purchase of raw materials in a particular financial year against sales tax due on the entire sales transaction of finished goods in the same financial year. Full stop. The tribunal, however, did not interfere with the enhancement of the GTO and TTO by rupees 1 lakh by rejecting the SSC's books of account. Paragraph. Although the tribunal correctly noted that in taxing statutes, a strict interpretation is to be adopted, it expanded the meaning of the expression open quotation to selling dealer to include any selling dealer and not the immediate selling dealer vis-a-vis the SSC. Full stop. This despite note 1 very clearly stating that the tax collected from the SSC by the selling dealer has to be shown, open quotation, separately in the body of the bill in respect of sale of raw materials and consumables, subject to tax on sale turnover directly used in the manufacture of such goods. Full stop, unquote. Note 2 also talks of set-off in the following manner. Take from note 2, Roman small 3, page 26.
Note 1 is also, my lord.
Sorry?
Note I is also, my lord. Note 2, Roman I.
Yeah, 1 and 3. 1 and 3, right. Paragraph.
One says, my lord, amount of sales shall be limited to the Orissa salary payable on sale of finished
products. Correct.
manufactured out of such raw materials.
Correct,
So proportionate to the raw materials.
Correct. Paragraph. Consequently, you see the language of note 1 being unambiguous. There was no scope for the expression open quotation, the selling dealer, to include any selling dealer not limited to the immediate selling dealer vis-a-vis the SSC. Full stop. The purport of note 1 was clearly to imply only the person from whom the SSC purchased the raw materials and not any previous seller. Full stop. There was no scope for expanding the expression open quotation, the selling dealer, unquote, to include any selling dealer previous to the involved in the transaction previous to the transaction on hand. Full stop. Consequently, the court is not able to agree with the approach of the tribunal in interpretation of note 1. Full stop. Question number 1 is accordingly answered. In favor of the revenue and against the SSC. Paragraph. As far as note 3, question 3 is concerned, on a collective reading of clauses Roman small 1 and 3 of note 2, it is plain that the set-off has to be only proportionate to the actual raw material used in production of the finished product of that particular financial year. The approach of the STO therefore seems to be correct. STO, as affirmed by the ACST. And the interpretation placed on the above clauses appears to be correct. Stop. Here again, the court is unable to concur with the view expressed by the tribunal. Question 3 is also therefore answered in favor of the revenue and against the SSC. Full stop. In view of answers to questions 1 and 3, the answer to question 2 is also to be in favor of the revenue and against the SSC. Full stop. Accordingly, the impugned order of the tribunal is hereby set aside. Full stop. The revision petition is allowed in the above terms.
The connected stairway is of the OST. First one is OET, second connected is of OST.
OET, is it?
Connected 135 is of OST, Orissa sales tax.
First one is OET.
OET, entity tax.
All right. In view of the order passed today by this court in STREV 136 of 2011, the present revision petition is also allowed. And the questions are answered in the same terms.
Milords, my pardon, Milords, item 16, I have passed on the orders to the court pastor.
All right.
Weekly list item number 18.
None appears disallowed.
Weekly list item number 19.
Item 19, my lords, 19 and 20 both are out of a batch of 24 appeals that were filed earlier, out of which 5 have been allowed by this court. I'll just pass over the judgments, my lord. And also those, the rest can be called and they can be disposed of. They consist of 2 different sets of principles based on contingent contracts. I'm just passing. I'm so sorry, my lords. I should have got 2 copies by mistake.
In view of the judgment of this court dated 30th September 2014 in WA numbers 181 and 182 of 2012, bracket Food Corporation of India, Bhubaneswar vs. Messrs. Vinayak Food Products, bracket, which were directed against the same impugned common judgment dated 3rd March 2012, passed by the learned single judge, which is assailed in the present appeals, these appeals are also allowed in the same terms. And the impugned order of the learned single judge in the corresponding OJCs, that is 7066 of 1997 and 1719 of 1998 are hereby allowed. Paragraph. You say separately on mentioning the above appeals are taken up on board. And same in view of the order passed by the division bench on 30th September 2014 in WA number 181 and 182 of 2012. These appeals are allowed. And the corresponding order, common order of the current single judge.
Well, in the second set of cases, the judgment also I have passed on. There's 2 sets of cases. So the copies that I've given, my lord, they're 2 different judgments.
Oh, no, the first in 18 and 19, it's which judgment? Even 19 and 20. In items 19 and 20, which judgment applies?
181, 182, 183.
And then is 183, 184, 185 applies in which ones?
They're for tomorrow, my lord. They listed, both the matters are listed for tomorrow. So today, my lord, 181, 182, 183 applies.
Sir, 181, 182 is in one judgment, 183 is another judgment.
My lord, I'll just.
They show him all the judgments. No, show him the other judgment also. It's only 359.
And
182, my lords.
Today's.
My lord.
So these other things we'll do tomorrow.
Tomorrow they're already listed in the bench.
So why do it today?
My lord.
Weekly list item 21.
Senior advocate Mr. Manoj Kumar Misra is supposed to place this matter on behalf of the appellants. He is not well and has undergone surgery. Therefore, I pray for an adjournment of the matter.
What's the matter about one?
Say, writ appeal challenging the honorable single judge judgment.
Leave to appeal. Leave to appeal.
Leave to appeal. But lordship sees they are intending to challenge the order passed by the honorable single judge. And in fact, the order passed by the honorable single judge in terms of the earlier division bench order passed by this honorable court as back as in the year 1997. So,
No, and that division bench judgment is what?
that honorable division bench judgment is holding an auction in respect of the property of Radhakant Math. There is a
Same Radhakanta Math only, here also.
But I am appearing for those private parties who are the auction purchaser. There was auction conducted before the honorable court only. And Sushant Misra became the highest bidder. The direction was given to execute sale deed in favor of Sushant Misra. But thereafter what happened, instead of executing sale deed in favor of Sushant Misra, sale deeds were executed in favor of nominated persons of Sushant Misra by the power of attorney holder. But subsequent to couple of petitions came before this honorable court challenging those sale deeds. Honorable division bench again directed to hold an inquiry conducted, and it is concluded that those sale deeds are illegal and void. Now, consequent thereupon, sale deeds were directed to be executed in favor of Sushant Misra in terms of the earlier division bench order. That in fact, the endowment commissioner's report declaring the sale deeds illegal and inoperative was challenged before the honorable single judge. Now, honorable single judge has upheld the cancellation. Honorable single judge has upheld those sale deeds are not correct, and also directed the sale deed be executed in terms of the earlier division bench order in favor of Sushant Misra. That is what the direction is.
Yeah, there is no stay. So that sale deed, there is no stay by the division bench
There
here.
is no stay here.
No, that is a leave to appeal matter. They prayed for a leave to appeal matter. They were the intervener, they prayed for leave to appeal to file appeal, writ appeal.
But anyway, there's no interim order here.
No, there is no.
So the sale deed in favor of Sushant Misra stays.
No, there is no stay order, I think.
No. The sale deed remains. It has already been executed. Not been executed.
That is because of the pendants of the
Self-imposed stay.
Yes.
There is no stay order here.
There is no stay order.
Anyway, counsel for the appellant is stated to be unwell. Learned senior counsel, appearing on behalf of the appellant is stated to be unwell. List on 16th November.
Weekly list item 22.
In item 22, I am for the second case for the petition 2009.
18031.
Madam.
Who is appearing 951, sir?
959.
Sir, a settlement, Bhaibandamasta land was settled in the year 1995.
Sir, who is appearing in writ petition civil 959 of 2012?
Now that is next case I am.
I am appearing in the next case, connected case.
Who's appearing?
My lord, I am in the first matter, my lord, 959. But actually, I have got no instructions, and the file is also not available. So I cannot
You
really.
say 959 of 2012. Mr. Acharya states that he has no instructions, and the file has also been taken away from him. The writ petition is accordingly dismissed for non-prosecution. Now come to 18031 of 2009.
Here, my lord, the revisional order is challenged before my lord. That revisional order was passed under a government circular. Setting aside the order of the Tahsildar passed in 1995.
Right.
My first submission before my lord would be, without explaining 14 years of delay, the so much power has been exercised. Of course, the circular does not provide any limitation so far that circular is. My first point would be such. Then my second point would be before my lord would be, the court found some procedural lacuna in the proceeding. The court should have remanded the matter for fresh consideration, but it has allowed the matter so much revision. These two are the point. Third point, I have not been heard and it was passed ex parte.
But were you served?
Lordship may look at page 18 of the revisional order. Page 18 of the brief.
No, I think the presumption of service is there.
Yes, my lord.
Because the RD card did not come back.
My lord. Now, this opposite party number 1 was, notice was served on him. But on the relevant date, he filed an application through a lawyer, which had been taken into consideration in para 2, para 3. He has taken
after adjourning on his behalf, he doesn't appear on the next date.
Yes, my lord. He appeared, but he on the date of hearing, he did not.
I filed an application that I was ill, but court did not allow it and passed the final order. My main point would be, Lordship may look at page 18.
No, not that day, sir. They gave another opportunity.
Yes.
He did not appear on 29 June. Then the case was posted on 20th July. On 20th July, nobody appeared again.
I don't kindly have a glance at page 6. I'm sorry, page 17, paragraph 6. The service jagirs were also abolished by the OE Act. The service jagir holders too were entitled for settlement of the land they were holding as service jagir, either under section so OE Act. The ex-service jagir holders too were required to file the claims within the statutory period. Thus, some of the ex-estate vested land would either be settled with the ex-intermediaries or with the ex-service jagir holders under the provisions of the OE Act and with same holder. On expiry of the statutory period for filing the claims of settlement of land by the ex-intermediary and the ex-jagir holder, the government had issued a series of circulars to help those who had failed bona fide to their claim for the settlement of land within the extended statutory period mentioned above. They could file the claims up to 18/1/1977. It was clarified in some of these circulars that vested land could also be settled with the transferees of the ex-intermediaries and ex-service jagir holders subject to certain conditions. The foremost condition was that such a transaction must have been made through a registered document. Moreover, the settlement shall be confined only to those lands which the ex-intermediaries and the ex-jagir holders were entitled to under the provisions of the OE Act. And they filed their claims in time. It was subsequently directed on 14/2/1970 that the Tahsildar should so much to start the case for the settlement of vested land with the ex-intermediaries, the ex-jagir holders, and their transferees. The benefit of the settlement not available under the provisions of the OE Act were not available under the executive instruction also. All these executive instructions were superseded and consolidated in revenue departments. This is important. There is a circular that all these previous notifications were superseded. This so motor revision petition has been instituted under the aforesaid jurisdiction of the member board of revenue. Perusal of the case record of the OEA case number so-and-so of the court of Tahsildar Puri reveals that the procedure prescribed in the circular for settlement of Bebondo's land had not been followed. A notice by PR number not that given was issued inviting objection. It was not given a date. It was only facsimile signature of K. Sarangi as Tahsildar. The process server has endorsed that it was proclaimed on 26/1992 in the locality and signatures of witnesses obtained. The names of R.N. Prushti and Rajkishore Haldar were written on the backside of the proclamation purportedly as the witnesses. These are certainly not the signatures of the witness because both the names have been written in the same handwriting. Signatures of Rajkishore Haldar available elsewhere in the record are totally different. This proclamation seems to have been fabricated with the Tahsil office. No notice was given by conducting local inquiry. No memorandum of local inquiry was prepared and placed in this case record. Nothing was brought on record in OA case number so and so that the opposite party number 1, with whom this suit land has been settled by Tahsildar Puri, is either the ex-intermediate or the ex-service dagger holder or their transferee. He has failed in this court to establish himself as the one. Therefore, he is not entitled to settlement. So, not only there is a case of fraud and manufacture of documents, but also he is not found to be the ex-service holder or Jagir holder, nor any transferee under the ex. Therefore, the OA revision was and the lease was cancelled.
No, what is the answer to that 14-year plea?
14 years, there is no, the government notification nowhere provides any limitation for this initiation of this so motive.
And anyway, fraud vitiates all transactions.
Pardon my lord. And your lordship knows Vrindavan Sharma case, your lordship is dealing with those case law in many cases, that in case of fraud and misrepresentation and this manipulation of documents, this limitation ground will not. And my learned friend has also admitted that the notification basing on which this home auto revision was initiated nowhere contemplates that the revision has to be initiated within a particular period, that is within 14 years.
Right.
That OEA case under section 7A, your lordship is thinking ADM power to cancel the lease, that is prescribed 14 years. That is
in reply, my lord, I shall say, so far first point is concerned, it was previously guided by 77 circular. Now 2000 circular has come and it superseded all of previous circulars. So in 2000 it was come, it was exercised in 2009. There was no whisper in the impugn order about anything so far 14 years of delay, number one. Number two, your lordship has gone through, I need not waste your lordship's time in taking. Here he has not decided anything on merit. He says that I was a tenant. He has not decided anything. He was only says those procedural irregularities. If any procedural irregularities, the matter should have been reheard by complying those irregularities.
Yes.
In those two counts, my submission would be this order has to be set aside. The matter should be considered.
If it's a fraud, why should it be sent back, sir?
Para 11, he has discussed about the merit of your case, that you are neither a ex-intermediary or ex-service dagger holder or any transferee under both of them, either of them.
Right.
That is in para 11. And it is categorically held.
And also, my lord, I was not hard in the matter. I was a tenant.
No. You are given enough opportunity for that, sir. Paragraph.
That is all, my lord.
Yeah, you see, this is a writ petition challenging an order dated 14 September 2009, passed by the Board of Revenue Orissa in OEA-RC number 17 of 2009. Whereby the orders dated 27 January 1995 and 21st November 1996 of the Tahsildar Puri in OEA bracket S bracket case number 84 of 1991, sorry, 841 of 1991 has been set aside. Paragraph. While directing notice to issue in the present petition on 8th February 2010, this court directed status quo to be maintained. Stop. That interim order has continued since then. Paragraph. It is seen that initially the Tahsildar Puri passed an order on 27 January 1995 settling land in Khata number 771, plots 1426 and 1428 at measuring AC 0.152 decimal. in favor of opposite party number 1. And full stop. Exercising the suo motu revisional power. Notice was issued by the Board of Revenue to the present petitioner, which was received by him on 14 May 2009. Stop. As far as the administrator of the Lord Jagannath Temple and the endowment commissioner, bracket, were opposite parties 2 and 3 before the Board of Revenue, bracket. Notices sent by registered post were not returned after the statutory period of 30, expiry of the statutory period of 30 days, and they were presumed to have been served. On the paragraph, the member Board of Revenue noted that while a counsel appearing for the administrator, Lord Jagannath Temple, was, appeared on 29 June 2009, none was present on behalf of the present petitioner and the endowment commissioner on that date. So the case was again posted on 20 July 2009 for hearing. So again, none was present on behalf of the petitioner. Paragraph. On 7th August 2009, a petition was received on behalf of the present petitioner that he had fallen ill and could not appear. Full stop. The Board of Revenue noted that nothing prevented the petitioner herein to file a written submission and original documents in support of his claim. Full stop. Thus, it was concluded that the present petitioner is deliberately avoiding appearing before the Board of Revenue. Paragraph, it is seen that the impugned order of the Board of Revenue is passed only on 14 September 2009. Having filed a vakalatnama on behalf of the petitioner before the Board of Revenue on 7th August 2009 itself, steps should have been taken by the lawyer engaged by him to appear and either plead for time or file the original documents. Full stop. He, however, did not do that. Full stop. The court is therefore not satisfied that there has been any denial of opportunity to the present petitioner to appear before the Board of Revenue, and therefore the Board of Revenue cannot be faulted in proceeding to pass the impugned order ex parte against the present petitioner. Paragraph. It is then argued that the suo motu revisional power is exercised nearly 14 years after the initial order passed by the additional Tahsildar, and that there is no valid explanation for the delay. Full stop. At the same time, counsel of the petitioner acknowledges that the notification permitting such suo motu revisional power does not prescribe any period of limitation within which it has to be exercised. Paragraph Mr. D.K. Mothi, learned AGA, points out how the
Para 8 of the impugned order at page 18.
The precise procedure prescribed in the circular for settlement of single quotes Bay Bandobasta unquote land has not been followed. Full stop. The notice did not bear any, inviting objections did not bear any date. Full stop. It only had the facsimile signatures of the Tahsildar. The names of two persons written on the back side of the proclamation did not bear their signatures. No notice was issued for conducting a local inquiry, and no memorandum of local inquiry is prepared. It is therefore plain that the settlement by the Tahsildar in favor of the petitioner in OES case number 841 of 1991 was vitiated, since admittedly the petitioner is neither an ex-intermediary nor an ex-service jagir holder or their transferee. Paragraph. It is then argued by learned counsel for the petitioner that even if the Board of Revenue found some procedural irregularity, the matter ought to have been remanded to the Tahsildar for a fresh decision on the request of the petitioner for settlement of the land in question in his favor. Paragraph. The finding of the tribunal of the Board of Revenue is that the proclamation inviting objections appears to have open question been fabricated within the Tahsil office. Unquote. In other words, the entire proceedings resulting in settling the land in favor of the present petitioner appeared to be vitiated by fraud. Full stop. In that event, there cannot be any objection on the ground of limitation. Full stop. Moreover, the notification itself, the government, does not particularly prescribe a period of limitation for exercise of the power of suo motu revision. Paragraph. For all of the aforementioned reasons, the court finds no error having been committed by the Board of Revenue in passing the impugned order dated 14 September 2009. Paragraph. The impugned order of the Board of Revenue is accordingly upheld and the writ petition is dismissed. The interim order passed by this court is hereby vacated. All right.
Weekly list item 23.
I 23 have a prayer, my lords. Actually, Mr.
My lord, I am.
He will, yes,
my lord.
I'm sorry.
Here, my lord, petitioner is a license holder of a IML offshore, my lord. Here, petitioner is a license holder of a IML offshore, my lord. Due to the objection made by the local people, my lord, his license and filing of the writ application, his shop was closed, my lord. Thereafter, after
demand notice is of 2011. Let him approach the
no, my lord. Regarding due to the closure of the shop, my lord, pursuant to the direction of this honorable court, he was unable to operate, and after dismissal of the writ application, the opposite party directed him to under Annexure 1, he has been directed to submit application for renewal of the license. Accordingly, he has submitted his application. Because due to the objection, his shop was closed by the authority, my lord. And thereafter, after disposal of the writ application, this honorable court has directed that he may submit application before the authority.
You're repeating yourself twice, thrice. Please proceed.
Sorry.
What happened after that?
Under annexure, the authority has directed him to submit the application on 21/4/2011, my lord. Accordingly, he has submitted his application for renewal, and thereafter his renewal application has been considered by under annexure 3, my lord, on dated 1/28/2000. After 5 months, his renewal application was considered and his shop was transferred to another place, my lord. Now they are demanding dues for the period wherein his shop was remained closed, my lord. Here, the shop was remained closed due to the shifting of the place from one place to another place, my lord, wherein it has been held in the similar circumstances. It has already been held by this honorable court that due to the laches on the part of the authorities in allowing the shifting application, the licensee holder is not entitled to pay the duty charges for the period of the closure, my lord.
Shows that.
My lord. Similarly, 3 to 4 cases and the similar cases has also been reported by our Honorable High Court. In the case of first case, in the case of OGC number
This court order.
666 of 2002, that shop was closed due to the objection, my lord, and that has been transferred. Subsequently, that has been transferred in the first case, my lord. 662 of 2019-92, man.
What do you say, Mr. Monty?
Yes, madam.
How can he be asked to
Miller,
pay for the period?
He
when-
has applied for shifting, and till the shifting order was allowed by the court, he is saying that his shop was closed.
Correct.
But he was he is liable to open the shop during that period. Nobody restricted him
No.
to
Not
close the
allowed
shop.
to open.
My lord, let the commissioner be directed to examine this in the light of that decision, and if he is entitled to get.
It has already been decided, my lord.
No.
Annexure 1 has
Let there be a decision on this subject by the commissioner.
only
because
one
commissioner is the
point is to be
authority.
decided. Only one point is to be decided.
You can place this decision before the commissioner.
Why?
And
It has already been decided whether during the period of
because the
shifting.
amount, as your also will find annexure 5 is 10,54,000.
Only
So he is no more a
15.
licensee. So if he is entitled to get the exemption because of this particular ground, let him place before the commissioner, because in all the cases your lordship is directing the commissioner to examine this matter.
Regarding the
All
shortfall.
demand matter, all
is-
demand notice
That
matters.
is regarding the soft flow MGQ. Regarding
No,
the lifting
shortfall
of soft flow
MGQ, other
MGQ.
regions also.
This is the case of
Because the
transfer, my lord.
commissioner is the head of
Petitioner is
this.
aggrieved by a demand notice dated 19th October 2011, issued by the Sub Inspector of Excise, Bhubaneswar, Charge 1, District Khurda, asking him to deposit rupees 10,54,488 on account of excise duty on IMFL/beer, MGQ, and monthly consideration money in respect of his IMFL off shop at Anantapur PS Balyanta, District Khurda,
That has been Antapur. That has been transferred to
For
Antapur, my lord.
period-
Under Annexure 3.
April to July 2011. Paragraph. The ground on which the demand is being resisted is that the concerned IMFL off shop was already shifted to
Anantapur, Annexure 3.
Yeah.
Yes, my lord, 37.
1 minute, sir, 1 minute. Came to be sealed on 22nd May 2010 by virtue of an order passed by this court in Writ Petition Civil 8037 of 2010. Full stop. But since there was no particular direction in the said order that the petitioner's shop should be closed, petitioner's shop, which was operating in Trinath Bazaar, to be closed. Another writ petition being Writ Petition Civil 108,448 of 2010, bracket Bimal Parija versus State of Orissa, bracket was filed in this court. Full stop. By an order dated 11 June 2010, this court directed that the shop would not be opened, if not already opened at Trinath Bazaar by that date. Full stop. Subsequently, after disposal of WP Civil 8037 of 2010, writ petition civil 10448 of 2010 was also disposed of by this court on 7th December 2010. With the observation that the present petitioner had been granted the privilege license for running the said op shop, and that since no liquor was consumed in the premises of the said op shop, the restrictions imposed under Rule 34 of the Orissa Excise Rules 1965 had no application. Paragraph. Pursuant to the above order, the petitioner is stated to have filed a representation for with the opposite parties 4 and 5. That is the Superintendent of Excise Khurda and Sub-Inspector of Excise Bhubaneswar for reopening of the shop.
Hello.
But the said representation was not acted upon. Ultimately, the petitioner reopened the shop in the Trinath Bazaar area on 26 January 2011. Full stop. Thus, it is pointed out that between 22nd May 2010 and 25th January 2011, the petitioner's shop has been closed. It is stated that the formal renewal of the petitioner's license was granted only on 29th April 2011. And even then, he was orally directed to relocate his shop within the Anantapur Mauza. Full stop. It is stated that with much difficulty, he selected an unobjectionable site there and filed an application on 21st May 2011. It was only on 2nd August 2011 that the renewal order was corrected from Trinath Bazaar to Anantapur and a license was delivered to the petitioner. Paragraph. Accordingly, the petitioner has averred that during the entire period up to the point of renewal of license for operating from Anantapur, the petitioner was unable to operate the shop. In other words, it remained closed from 1st April 2011 to 2nd August 2011 on account of the belated decision taken by the excise superintendent. So in the circumstances, the impugned demand notice demanding MGQ period from April to July 2011 was not justified according to the petitioner. Paragraph. What is your explanation, sir?
We have filed the counter affidavit. Your Lordship may kindly have a glance. We have filed the counter affidavit. page 8 of the counter affidavit, last for 3.
No, but you're admitting that,
Right.
that because of the High Court's order,
No. We are not admitting. Your Lordship may kindly have page 8 of the counter affidavit.
no. First come to page 6 bottom.
Page
6 bottom.
As per
So in order to, yeah.
as per interim order passed by the Honorable High Court dated so and so, passed in so the petitioner were intimated this fact to the petitioner in person a number of times by Sub-Inspector Excise Charge 1 Bhubaneswar to shift his shop to Tinath Bazar as per license, which he failed to carry out. So in order to comply the order of the Honorable High Court, specifically order dated so and so, passed in the petitioner at Bhimpur was closed.
Bhimpur is where Trinath Bazar is.
Srinath Bazar.
Same.
Srinath Bazar is constituted by marketplace, constituted by Bhimpur and
The
Antapur and
petitioner had got
Jagannathpur.
license for the year. But if your Lordship will see paragraph 10,
No, but there was an interim order saying if
Yes.
you've not opened a Trinath Bazar, you should not open.
it should not open. But the impugned demand notice relates to the year 2011-12 was not covered by the stay order of the Honorable High Court. That
No,
is the-
maybe.
That is
But
separate.
the point is that
That is
he
a-
was not allowed to function in Trinath Bazar.
Yes.
And when he applied, saying, let me shift.
And not allowed to operate by the general public as has been alleged by him.
Pursuant to the
No. There is a High Court order also.
No. That
It
is
is
what
a
I want to convince your Lordship, that so far as the stay order period is concerned, this demand notice does not relate to that period. That is my specific averment at page para 10, page 8 of my counter affidavit.
After disposal of the writ application, I have submitted application under Annexure 1. And they have directed
That
me.
is why, since there is factual controversy, that is
No
why
factual controversy.
I pray your Lordship that Lordship may remand it to the Excise Commissioner. He will examine all these things. If by virtue of the court's order, his shop was closed and our demand notice is relating to that particular period, then something can be done. And but these are all factual dispute as has been pleaded in my counter affidavit. This is not relating to this stay order period.
In my rejoinder affidavit, I have specifically about that. Due to the stay order, I have been debarred from operating. Even if there is no direction from this honorable court to seal his shop, the inspector of excise has sealed his shop, my lord. Thereafter, I have moved before this honorable court in 7049, my lord. There is a specific direction that his case may be considered, and accordingly, under Annexure 1, I have been intimated by the superintendent of excise to submit application for
And he's
renewal.
ultimately got shifted, no?
Yeah,
The
accordingly,
license
that
also
has
changed to.
shifted.
Ultimately, it was shifted.
Shifted.
Yeah, then
And that remain closed from 1 for.
I think we should.
The only
You see, in para 10 of the counter affidavit filed, it is ought to be contended that the period during which for which the demand has been raised, that is April to July 2011, open quotation, was not covered by the stay order, unquote, of this court. So, however, it is pointed out in the rejoinder affidavit by the petitioner that the petitioner was compelled to approach this court in a separated petition when his repeated request for shifting from Trinath Bazar.
No, regarding shifting, no, regarding the previous year license with demand notice.
There are also other demands.
That is
Not
previous
only-
years, my lord.
Anyway, this
That is
demand
separate
notice,
issue.
that is what I am submitting. This
Only
impugned demand notice not only covers the duty for that particular
No.
period, but also other dues also.
No, my lord. This is demand notice pertaining to the shifting period from 1/4/1911 to 1/8/2011, my lord. 12. That is only for 4 months, my lord.
No, when was your representation for shifting? Your application was shifting. When did you make it?
My lord, Annexure 1, my lord. Pursuant to the direction of this honorable court, they have intimated us to submit the application, my lord. At Annexure 1, page 10, my lord. You are hereby directed to submit your application for renewal through the concerned charge range
Yeah.
excise officer on completion of requirement.
It
Accordingly,
is
I have
pointed
submitted.
out, yeah, it is pointed out that by a letter dated 21st April 2011, the petitioner was asked to submit his application for renewal
And
through the concerned excise officer,
Right.
quoting the direction issued by this court on 29 March 2011
Yes.
in this case number 4638 of 2011, arising out of writ petition civil 7049 of 2011.
Yeah.
Full stop.
Accordingly, Annex 3 has been allowed. On
This
2/8/2011.
application was allowed
2/8/2011.
only on 2/8
Annex 3.
2011. Full stop. Paragraph. Clearly, therefore, the petitioner could not have continued operating at Trinath Bazaar during this period. Full stop. The license for for him to operate the IMFL op shop from the changed location at Anantapur, having been issued only on 2nd August 2011, and the petitioner's shop having been closed till then, or on account of the above factors, the court is of the view that the demand notice dated 19th October 2011 is unsustainable in law. Paragraph. The court notes that in similar circumstances, this court had passed an order on 14 September 1993 in OJC number 6662 of 1992, bracket Sarat Kumar Rath, the state of Orissa, holding that a demand raised for MGQ shortfall for a period during which an IMFL op shop is shut for reasons beyond the control of the license holder, cannot be sustained in law. Paragraph. To the same effect are the orders dated 10th May 2011 of this court in WP Civil 8433 of 2011, bracket Srimati Sakuntala Shahu versus State of Orissa, and the order dated 1st May 2015 in writ petition civil 6132 of 2014, bracket Golaka Bihari Patnaik versus State of Orissa. Paragraph. For all of the aforementioned reasons, the court quashes the demand notice dated 19th October 2011. The writ petition is allowed in the above circumstances. In the above terms, no orders is to cause.
Weekly list item 24.
Before my lord, the petitioner company is before the NCLT, my lord. I have filed the NCLT order, my lord.
Counsel for the petitioner points out that the petitioner is guilty in CPIB number 250/KB/2021, in which an order has been passed on 5th May 2022. That view of the matter, it will be open to the parties to approach the NCLT for any appropriate directions concerning the issues raised in the presentation. The petition is accordingly disposed of.
Weekly list item 25. My bill.
Item 25 has become infructuous, my lord, because the earlier writ petition has already been disposed of by this honorable court, my lord, and I am for OP6, my lord.
May I please?
My lord.
Challenging Annex 10, my lord. It has been issued by collector cum district level land sale committee issued in favor of OP number 6, who is no way connected with the present land, my lord. Land belongs to, my lord, Jagannath Temple Committee Road, my lord. The lordship, they have issued a policy decision on Annex 7, my lord. 3 documents are there which I rely upon. All are in vernacular language, my lord. I'm very extremely sorry that I have not filed any translated copy.
How come no counter is filed in this?
My lord?
I have already filed counter, my lord.
Where?
No,
In which one?
Counter in 2014, my lord.
No copy has been sought.
No, 10356.
My lord, that is in case 10356, and the I have filed counter. My lord,
When did you file it, madam?
My lord, in 2014, after getting notice,
There is no date. Just one in the whole year you filed without a date.
No, my lord. My lord, I have already filed my lord counter. My lord, in August 2014, I have filed, my lord.
No date in August, madam.
My lord, I am coming, my lord. In my file, it is reflected that August 2, my lord. August 2.
Where is the diary number? Tell us the diary number.
My lord, that is not in my, because at that time, my lord, counter only.
The counter
filed-
affidavit is not on the court record.
My lord, I have already filed because at that
Madam,
time.
you come here and you check the court record, we are unable to find any such counter affidavit.
My lord,
You have not served the counter affidavit on counsel for the petitioner. He also does not have a copy.
No, my lord, I have solved, my lord, that because at that time the counter affidavit was.
Madam, if you want to just record these statements, we'll say that none of this exists on the record.
My lord, then I will file another counter copy of the counter, my lord. Because
When was notice issued in this person?
My lord, I may be pardoned, my lord. Am I audible, my lord?
Petition, my lord. No notice has yet been given to me, my lord.
Now you're arguing something else altogether. Anyway.
Now the opposite party number 6 is in person. Mr. Gokulananda Padi.
OP number 6, yes.
My lord, I may be pardoned, my lord, to be heard, my lord. I am for OP number 6, Mr. J.N. Padis himself, my lord. Am I audible, my lord?
Yes.
The counter has been filed, my lord. Before that, my lord, there is a case, WPC 11588 by 2009, my lord. That may be come to record, my lord. Counter already filed, and that is by after 2009, WPC 11588. That may be come to record, my lord. The counter affidavit filed before, my lord. I am on.
In both these petitions, it is not even listed once. The second Sanjulata Panda case, it is not even listed once in 10 years. So strange. There is no order, nothing, no notice. It is not even listed. This is the first hearing of the petition is today.
My lord.
Sanjulata Panda.
Sanjulata.
The next connected matter.
Oh, yes.
Who's appearing for the petitioner in the connected matter?
Sure.
Anyone appearing? Sir, are you appearing?
No.
In 12899, you say none appears for the petitioner, dismissed for non-prosecution. In 10356, you're there.
Yes.
Tell us what the matter is about.
Yes, my lord. Petitioner is, the father of the petitioner is occupying the land since 1973, my lord. That is Annexure 1, that they have circulated that I'm holding that in peaceful possession in 1973, my lord. Then I've constructed a house and staying with my family, my lord. And all the connection, your lordship will find Annexure 3, that is the electricity connection that was in favor of one Biravar Padi, the father of the president.
No, what is wrong with the notice? You've challenged one notice dated 15 September 2008.
My lord, yes.
What is wrong with that notice, you tell us?
The person concerned against, in favor of which notice has been issued, my lord, he is no way connected with the present case, my lord. Because legally, the person...
No. In whose favor has this notice been issued?
Yes.
To whom has the notice been issued?
Biravar Padi was holding the field, my lord.
You're not answering the question.
He died in 2001.
1 minute, sir. You're not answering my question.
Sorry.
To whom the notice has been issued as per Annexure 5?
OP number 6, madam.
Gokulananda Padi.
Yes.
So how are you aggrieved by the notice being issued to him?
Because he has been asked to deposit the amount to purchase the land in question, my lord.
All right.
Because I have
But no order has been passed.
No order has been passed.
So it's premature then.
No order has been passed. Well, he has been asked.
So he's only been asked.
Instead of notice.
Then why don't you go to that authority and file an objection? Why have you come here?
Because, my lord, since notice has been issued and he has been...
why should you not go to the authority to say why are you issuing notice to him? You have to object. You object to that authority?
Yes, I'll approach the authority.
Counsel to the petitioners aggrieved. No. The petitioner has come to this court aggrieved by a notice dated 15th September 2008, issued to opposite party number 6, requiring him to deposit some amount for purchase of a property at Halkata, 877, plot number 847, unit number 32 of Madhupatna, district Cuttack.
Yes.
By paying consideration amount of rupees 241,500. Full stop. It is seen that in the present petition, which was filed way back on 5th June 2012, no notice has even been issued till date. There has been no interim order passed. Full stop. If the proceedings arising from the impugn notice are still pending, as is claimed by the petitioner, then it will be open to him to go to the authority who issued such notice to raise any objection that he may have to the issuance of such notice to opposite party number 6. Full stop. The court does not wish to express any view on the merits of the contention of the petitioner. So it will be for the authority to take an appropriate decision after taking into account the objection of the petitioner. Full stop. No further directions are called for. The petition is disposed of.
Kill list item 26.
Item 26, Lord, I appear for the petitioner. But here, the petitioner has challenged an order.
No, notices could not go to opposite party number 3 because you do not file the requisites.
No, we have filed the requisites.
Just look at the noting, sir.
Yes, but
we can't hold an inquiry into that. This is not the place to hold an inquiry, and that too, notice was issued when was notice issued in this case? 12th November 2012, 10 years ago.
Yes, at that time.
And till date, for almost 10 years, no steps have been taken to serve opposite party number 3.
But your lordship may direct the office to verify because we have our concern. We have
who's opposite party number 3? That first page is not scanned.
Opposite party number 3 is Mutt. The
where's the cost title?
The seller. One who had filed the petition to sell the land.
This page has not been scanned. No, it's some Mahanta Adhikari. What are you aggrieved by, sir?
Pardon me.
What are you aggrieved by?
Lord, I am aggrieved by the order under Annexure 5, whereby the state government has refused or rejected my prayer under section. My prayer means the opposite party number 3 prayer. I'll just go to the background for brief background. Lord, opposite party number 3 is a Mutt. Mutt wanted to sell 12 acres some odd properties. So the Mutt approached the commissioner for permission under section 19. Permission was granted and it was directed that the property should be put to auction with the base price of 25 lakhs per acre. Now, that property was put to auction. In auction, I was a valid auction purchaser. The petitioner was a valid auction purchaser. What he did, Lord, he deposited 1 crore rupees, 1 crore some odd, saying that for the rest amount, I may be given some time to deposit. Lord, when he deposited 1 point some odd lakh rupees, he requested the authority to execute a sale deed for 4 acres, which covers the amount deposited at the price directed by the commissioner. And in fact, 4 acre sale deed has been executed. Now, against that prayer to extend the time for deposit of the rest, the commissioner was approached. The learned commissioner allowed the extension and said that 25 is not correct, it is 50 lakhs per acre. Maybe now he had the idea that the price must have gone up or anything, that is there. The suo motu revision was taken up by the government. In that, my entire prayer has been rejected, my money has been forfeited, the sale deed have been cancelled. Lord, your lordship may see one thing. I can understand, my lord, he can say that 50 lakhs is not enough or whatever it is in the above state of affairs. Lordship says, whether the finding of the Land Commission of Renewal that the sale for unspecified land of 4 acres is valid, which is founded upon contradiction and also contrary to law. Therefore, the sale deed not being in accordance with the order of permission is held to be void. It is declared. This is one thing. To declare it void. So you said that no, the property will be put to auction again and anyone can purchase. But where is the question of depriving or forfeiting? There is no forfeiture clause also. Forfeiting my amount which I have deposited and saying that 50 lakhs is not enough or
No, where is the forfeiture?
page 43.
OP2 is also found not to be entitled to refund.
Yes.
Oh.
But he has directed that it should be sold in piecemeal for put to auction, everything okay. It's all right. But how I should be punished? I participated in an auction. My only prayer was to extend time for depositing the balance amount. Yes, if it is rejected, it is rejected. I would have been satisfied with 4 acres. He cancels the 4 acre sale deed. He forfeited my deposit and everything.
How do you defend this forfeiture? Under what provision can you forfeit the entire consideration amount like this? He has not played a fraud. He has got valid orders. In fact, when he said he cannot deposit the entire amount, he said, can you have a sale deed for a lesser extent? You people agreed, and that's how the sale deed was executed.
Page 40, paragraph 5.
Ah.
Here it is observed. Before going to take up the issues, it is felt pertinent to state that the Land Commissioner in such cases go to fix the time limit for fixes for completion of sale while permitting sale of property of the institution as a mandatory condition only in the interest and to benefit the deity.
So this entire thing is done suo motu, right?
So,
if it is done suo motu, you can't just presume fraud. There has to be some material to show collusion, fraud, or anything, or loss to the exchequer. It is not that you have lost land.
There is
for the extent you have sold 4 acres, you have sold, you've got the consideration for 4 acres. Yes. If you now feel that it should not have been sold as 4 acres in first shot, the remaining in the next separate sale deed, and therefore you're cancelling the entire sale, you can't just forfeit the money.
You may consider so far as forfeiture is concerned.
He will be satisfied if the forfeiture is taken care of. He's saying whatever you want to do, reselling it, he has no objection to that.
That order he has given, it should be piecemeal, put to auction.
Correct. Right. He has no problem with that. He's only concerned about the forfeiture.
That's me.
For the balance 8 acres and all, you go for piecemeal auction, higher price, everything. So far as this is concerned, it is complete. It's not my fault.
No, but have you done anything? This land is still untouched, right?
Yes, untouched. There has been a stay order by the
so that's fine. Then. We don't interfere with the cancellation of the sale deed, but the forfeiture we will say is not warranted.
and limited that 4 acres will stand. Lord. That your lordship may kindly clarify.
What?
That your lordship will kindly clarify forfeiture, because that 1 crore some odd I had deposited against this 4 acres. Against this 4 acres.
No, you will get back whatever you paid, you will get back.
No, without the land, if I get, then I would honestly play subject to your lordship, then let them pay interest, because they have kept it with withheld it. Either I am satisfied if they give me 4 acres and take the money, or return the money with interest.
What do you say?
That commission can say.
No, it's not. Suo motu is done by the state.
No, so far as
The sale deed is
amount,
complete.
because he is interested for interest on the deposited amount. But the amount was paid to the.
No. If you want the cancellation of the sale deed itself to be upheld, then you have to give him back the money with interest.
Because that money has been deposited with the commission. But my learned friend is representing the commission.
My name is not reflected. It is 2012 matter. So that I pay one next week, so that I take instruction about the matter, what is the position of the matter, and
You see, the petitioner, who happened to be an auction purchaser of land belonging to the opposite party number 3 Mutt, pursuant to a public auction, has challenged an order dated 25th May 2012, passed by the Principal Secretary to the Government of Orissa Law Department, cancelling the entire sale and also forfeiting the amount deposited by the petitioner. For execution of a sale deed in his favor of land to an extent of AC 4.00 decimal.
Annexure 1 is the sale deed.
Out of a total extent of, what is the total extent of the land?
12 acres. 12 acres.
AC 12.630 decimal. Stop. Paragraph. While issuing notice in the present petition on 12th November 2012, this court directed stay of the operation of the impugned order, dated 25th May 2012, as well as an earlier order dated 25th January 2012 of the Commissioner of Endowments, permitting the sale. To go through. Paragraph. Mr. Ramakanta Mohanty, Senior Counsel appearing to the petitioner, submits that the petitioner would be satisfied if the sale deed already executed in his favor to an extent of AC 4.00 is sustained. In the alternative, if the cancellation of the sale deed has to be upheld, then the amount deposited by him should be directed to be refunded together with interest from the date that he parted with the said money.
Lordship only observe the findings made in paragraph 10 of the impugned order at page 42. The state government has dealt with so far as forfeiture, reasons for forfeiture.
No, but this has to be on some basis. There has to be some material to show that this happened.
That has been discussed in paragraph 9.
I had no role to play. Paragraph
how
9.
The sale was conducted.
No, sale has been conducted on
15/2/2010.
2008.
2010.
Yeah, sale took place on 20th February 2010, right?
15/2/2010.
No, sale deed. Let's leave this.
That is there in paragraph 9 of the.
No, we have a copy of the sale deed itself. 15/2/2010.
Executed, sale deed executed and registered. Annexure 1.
2010. So
Annexure
he's
1.
asking for interest from that date, 15/2/2010.
Has paid the amount to commission.
No, that they have deposited. That they have deposited. They have to pay either. I'm saying either 4 acres.
So from the date it was deposited, that is 15/2/2010, the date of the sale deed. All right. Is a counsel for the commissioner says that he will have to seek instructions. At his request, list on 21st September, interim order to continue. That first page you have to get it scanned.
Weekly list item 27.
This arises out of an order passed by the civil court rejecting my application order 14 rule 2 of CPCB. Order 14 rule 2 of CPCB.
So how does the writ petition lie for all these kind of orders?
In fact, previously writ petitions were being filed, but after that judgment CMPs are maintainable. This can be converted to a CMP man.
All right. The challenge in the present petition is to an order dated 24th February 2012 passed by the second additional civil judge senior division in CS number 296 of 5/525 of 2010/2008. Stop. Since a civil revision petition is maintainable against impugned order, the registry is directed to convert this writ petition into a civil revision petition.
CMP, civil miscellaneous petition.
Civil miscellaneous petition. And after numbering it accordingly, place it before the roster bench on 27th September.
Can I pray your lordship there is an interim order?
Yeah, that interim order will continue. Yeah.
Great.
Weekly list item 28.
May I please your lordships? Well, here, my lord, the petitioner challenged the validity of the amendment of section 3(1) of Orissa schedule areas, transfer of immovable property by schedule type amendment regulation 2000, my lord, which prohibits transfer of the land belonging to a schedule tribe ST person in favor of non-ST person, my lord.
Correct.
Your lordship's last but one occasion, my lord, 8/3/2021 passed one order.
Yes.
My lords, may kindly have a look at your lordship's order, my lord.
Yes.
8/3/2021. The state had already filed a counter wherein in para 10, my lord, they stated that they have no comment so far. Paragraph 8 to 14 are concerned. That is why your lordship in para 6 of order dated 8/3/2021 directed the
Have they
state
filed
to
an affidavit?
Law department.
You took time on 22nd June also.
Almost 1 year and 3 months, my lord.
No, the law department counter affidavit.
ST when my ST
Time was taken again on 22nd June, sir. You say,
Last chance.
okay. Mr. D.K. Manthilan at AGA states that the affidavit in terms of the orders dated 8 March 2021. Well, the filing of the time for filing of which was extended by this court on 22nd June 2021, will be positively filed on or before 19th September 2022 with an advance copy to counsel of the petitioner, who's permitted to file a response thereto before the next date. List on 11th October, 12th October.
Weekly list item 29.
May it please your lordship. Lordship, I am in
Your
VC.
lordship, I am appearing on behalf of the opposite party workpen.
Right.
Your lordship, this is a challenge with regard to the award passed by the Rendered Industrial Tribunal Your Lordship may kindly have a glance at the page 14, the reference, Your Lordship. 1-4.
Yes.
Yes. Whether the refusal of employment of Sri Basant Kumar Khuntia and 44 others, as in Annexure A attached to the conciliation failure report, represented through Cuttack Commercial Workers Union by the management Mrs. Aditya Steel Industries Limited, with effect from 19/1/2005, which may amount to lockout, is legal and are justified, Your Lordship. If not, what relief they are entitled. Your Lordship knows that a termination and a lockout or strike, that all different subjects, Your Lordship.
Yes.
Your Lordship, this is a matter where the challenge was with regard to the employer-employee relationship between the petitioner, who is the principal employer, and the contract labor, who are the workers involved in the reference, and there are contractors, Your Lordship. May I take Your Lordship to page 18, Your Lordship?
Yes.
Because 3 issues were framed by the Land Tribunal, which are in the previous page 17. And in page 18, issue number 3 was taken up at the first instance for answer. Your Lordship, para 6. Your Lordship, that's it?
Yes.
18, para 6. Middle portion, Your Lordship. The management has examined MW number 2, who claims to be a contractor of the first party. Then, Your Lordship, 3 lines after that, he has named 13 out of the 45 disputant workmen as the laborers whom his firm, namely Messrs. Naik and Brothers, had engaged in that factory. He has further stated that those workers were paid wages from the establishment of the contractor. During cross-examination, he has, however, admitted that all the 45 workmen were employed through contractors and they had been working in the factory of the first party since 1990, Your Lordship. So this is a fact which has come, that they are employed by the contractors, Your Lordship. Your Lordship, then come to page 20, Your Lordship. I'll take Your Lordship to certain things because I tried to assess this thing, because now the establishment has remained closed and inoperative since 2010, while the matter was pending before the Learned Tribunal. Still then, the Learned Tribunal has awarded reinstatement. That is why I am making these submissions, Lordship. Your Lordship, page 20, Your Lordship. I'm sorry, page 21, Your Lordship. Because there are certain documents were called for from the management with regard to
but was the tribunal informed that the company is closed down?
Yes, that came in evidence, Your Lordship. Of course, I am sorry, because when I checked up yesterday, the evidence, I have not been able to file the evidence. But with the evidence of MW1 in para 28, it is recorded that since 20th November 2010, the factory has been closed. And the award is in 2011, Your Lordship. Find 17/12/2011, page 14.
Right.
And Your Lordship, here, page 23, Your Lordship.
1 minute. The unit is closed.
My instruction is still is they have also only they have shifted the point of location of operation, but the unit is now still functioning. My instruction is that.
Your Lordship, it is now ground zero. If you come from Cuttack to Bhubaneswar on the right side, you must have marked the Grand Bazaar which is coming up. That is the area where the industry was there. It is all ground zero, Your Lordship. There is
but
nothing.
They have shifted the unit of location. That is my instruction. But my lord is that if kindly glance to the affidavit, they have not also the affidavit filed by the workmen. They have not complied the 17B as well. And also my application
17B has not been complied with.
No.
Can you find out, sir? 17B, he says, has not been complied with.
My lord, says that, and I don't have.
And my application
here, but they have filed a 33C2 application for this entire wages that is continuing before the labor court.
My application is still
the award has been stayed, sir. What is the point in the 33C2?
My lord, that is continuing. Your 17B, they are claiming full wages from the date of termination, Your Lordship.
It is pending.
That
is pending. My 33C2 application is pending.
He says 17B have been getting up-to-date wages.
On all these are included in that 33C2 application, Your Lordship. All this period. But what I am suggesting, Your Lordship, may kindly come to page 23 for a moment, Your Lordship. If you give it, Lordship, 1 minute.
No, there is an affidavit filed here way back in 2013 saying you have not complied with 17B.
13 and 14, Your Lordship. Yes, it is there on my record also.
Series of
yes,
affidavit filed.
Yes.
Can you Can you confirm whether you have complied with 17B?
I can check up, your lordship, if you've got some time.
The management will file an affidavit. The petitioner will file an affidavit before the next date confirming whether the order passed by this court on 18/10/2012 directing wages under 17B of the Industrial Disputes Act 1947 to be paid to the opposite party workmen has been complied with. Based on 19th October.
Okay.
Interim order to continue.
Yes.
Weekly list item number 30. Item 30.
None appears. This is not.
Weekly list item 31.
None appears. This is not.
Weekly list item 32.
My lords, I am personally ill, suffering from teeth aching. Let it come next week.
No. What is the matter about it? Since you are here, let us see what the matter is.
My lords, the matter is that he has a workman, he has a watchman in a hostel, ladies' hostel. He has completed 367 days, but he was orally told not to go. This is way how he was services terminated. So he approached and that has been rejected. Being affected by that, I have approached to my lords.
What is his age now, sir?
They have not filed counter.
What is your client's age?
The client is a watchman.
Age.
Yes, my lords. Hmm? What? 45, 48 minutes.
He was 38 in 2012. 48 now. All right. So what is wrong? Just come to, it's a very short paragraph, para 8. What is the material to show that you were working?
My lords.
What is the material on record to show that you were working in the establishment?
My lord, that as you working, I have given I have got a experience certificate in page 9.
Page 9?
Page 9.
That experience certificate has been examined. Come to para 8, sir.
Yes, they have they say they have examined, that does not say anything. But the fact is, the certificate is a correct one, is not a forged one.
No, but does that certificate show you are working continuously?
Yes, I was working.
No, what does the certificate show? Let us read that. What does that certificate show, sir?
My lords, I am reading out. This is to certify that Sri Pradeep Kumar Dhar, son of Sri Kangai Charan Dhar of a village, Nihar Prasad, post Nihar Prasad, District Dhenkanal, was working as a watchman on a monthly contract basis in the ladies' hostel of this institution for a period of 15/7/91 to 17/7/92. That is 367 days. My lords, this certificate has been given by the principal.
Yes.
It does not say that he has worked for some days or not continuously.
Yes.
What they have written, I wanted a certificate and they gave a certificate. Had I the knowledge by that time that there must be 240 days or more, then I would have compelled them to kindly write it. So 1 year completed 2 days more. Should it be interpreted that no, that he is not working continuously? Because
No, it's the other way around, sir. You can't keep asking questions. You are going to the tribunal making a claim. You have to make good that claim.
yes,
You can't just ask a negative question and therefore say
I'm
it's
sorry.
proved.
All right, I'm putting the positive question to myself that I have worked and they said not to come. I did not go. When I went, then it was not necessary. Thereafter, they allowed another man to work, and the post has fallen vacant now. But your lordship kindly see page 31 on para 8, page 31.
Yes.
On perusal of Exhibit 1, Xerox copy of the one experience certificate, it appears that the same was executed by the principal, Grammar Sevak Talim Kendra Bhubaneswar on the 9th November 1996 in favor of the workmen. Even if this document, Exhibit 1, is accepted in its totality, it only shows that the workman was working as on a monthly contract basis of watchman for the ladies' hostel of the institution, that is Grammar Sevak Talim Kendra. From this, it appears that Exhibit 1 does not prove itself that the service rendered by the workman was continuous as defined in Section 25B of the Industrial Dispute Act 1947. There is no matter on record to show that the workman was in continuous service as defined in Section 25B of the Industrial Dispute Act 1947. No doubt, the onus heavily lies on the workman to prove that he was in continuous service as defined in Section 25B of the Industrial Dispute Act 1947. In the instant case, except oral evidence of the workman coupled with the experience certificate Exhibit 1 does not lead to any definite conclusion that the workman had worked under the management for 240 days in the period of 12 calendar preceding to the date of his termination as defined in Section 25F of the Industrial Dispute Act 1947. Therefore, it cannot be said that the workman is entitled to get the benefit of Section 25F of the Industrial Dispute Act 1947. Here, my lords, with the respect I would like to submit, is there there is no document before the PO that he has not come regularly or he has not done the work punctually. On the other hand, there is no he was in uninterrupted duties most satisfactorily and diligently. But there is no allegation against him anywhere else. Simply because the certificate did not contain that. They do not give any appointment to us. They allow us to work and we work. They say you don't come. That is why it has come to our protection. So, my lord, I will satisfy my lords that there are sufficient things to show and satisfy.
No, that you can't. There's nothing on record, sir.
My lords,
there is nothing on record except the same experience certificate. You are reading the same certificate.
Yes, ma'am. Yes, ma'am.
In fact, the matter was sent back by this court. This is the second round. It was sent back for you to adduce evidence.
Yes.
Again, before the labor court, you only produced the same experience certificate. You had no other material.
My lords, I cannot create the certificate or cannot create the records.
No.
But
what else is there then? Apart from this, there is nothing else.
My lords, there is series of decisions of this honorable.
No. Decisions don't supply facts, sir. Sorry.
Then I will come to, because I'm not feeling well. I'm on.
No. We are only on evidence here. There's no question of. There's no other evidence in support of this.
Yes.
And decisions will not supply evidence, sir.
Then, my lords, there are decisions.
Decisions will not supply evidence, sir. This is only one experience certificate, which does not show that you are continuously working.
My lords, if my lords is determined to dispose of the case, my lords can determine that I am not feeling well. That is only whole difficult.
What is this? What is the submission you are making? We are hearing you for the last 20 minutes.
My lords,
what kind of submission are you making?
I'm sorry, I'm withdrawing. But
you better withdraw, sir.
Yes,
we're hearing you patiently for the last 15-20 minutes. Yes, what do you have to say?
My lord, I am for OP1 image, and my lord, I would like to place this written statement filed by first party management, that is image. Kindly come to page, my lord, 15 for a moment.
Sir, kindly you take your seat, sir. Kindly take your seat.
16, my lord.
Yes.
Page 16, there is sub para.
Yes.
it may also be humbly submitted here that since the engagement of the second party was occasioned only due to the training program sponsored by the Director of Agriculture for a limited period and from the training cost only, no appointment order was issued by the first party management in favor of second party workmen, my lord. And the said engagement of the second party is absolutely for the sake of temporary period, kindly mark, my lord, for the sake of a temporary period occasioned due to the training program sponsored by this image Director of Agriculture. And the said engagement is neither a service, much less to be called as continuous service. Since the second party was fully aware about his engagement for a limited period up to the completion of said training program, there was absolutely no need for issue of prior notice to him to prior decision.
All right, we've read that. You're struggling to read also.
Yes.
Just okay. We'll just read it ourselves.
And there was also no necessity of payment of compensation to the second party. That was our submission before the presiding officer labor code, my lord. And another paragraph 10, page 17, that the second party had not been given any regular appointment.
Watchman, sir. There's no question of selection for a watchman and all that. Anyway. All right.
And
yes, sir. What else do you have to say? What else do you have to submit, sir?
I have to submit many things, but still I am not in a position to tell. I am unable to.
What do you have to submit? Tell us.
Let you know tomorrow, my lords, at least.
Counsel to the petitioner states that he's unwell, although he's argued for about 20 minutes and states that he wants to cite some decisions. This is on 22nd November. All right.
Weekly list item 33. Item number 33.
None appears to see not prosecution.
Weekly list item 34.
34 on behalf of Mr. A.K. Mahanti, kindly permitted to withdraw mail.
Kindly counsel to the petitioner says he wishes to withdraw.
Weekly list item 35.
My lordship, please. I am on behalf of M. Mohanty. We have no instruction about the petition.
Counsel to the petitioner says he has no instructions. Dismissed.
Weekly list item 36.
None appears to just no prosecution.
Weekly list item 37.
I may be pleased, your lordship. Your lordship, because of a non-compliance of the order of the Honorable Court, I have filed contempt petition for non-compliance of the order of the Honorable Court dated 15/9/2011. In my rejoinder reply, I have annexed all these documents, my lord.
You have also filed our complaints report, madam.
Hello?
You have filed our complaints affidavit.
You have filed?
Yes.
Already I have given reply to their complaints affidavit.
Yes.
To the reply, my lord, this reply stated Panel page 157, my lord, to my rejoinder reply to the complaints affidavit, my lord. 157. Against which order I have filed the contempt petition, my lord. In this order, my lord, the operative portion of this order in page 157 is, my lord, we dispose of this writ application in terms of the order dated 17/11/2005, passed in WPC number 14895 of 2004, and direct the opposite parties to extend the benefit that has been extended in WPC number 14895 of 2004 to the present petitioner within a period of 3 months from the date of communication of this order, my lord. What is this order, my lord? 1/4/2004, my lord. 17/11/2000, I have also annexed in this original reply, my lord. Page 151, my lord. 17/11/2005 in WPC number 14895 of 2004, my lord. Operative portion of this order, my lord, and page 154, my lord. In view of the above mentioned facts and circumstances, we are not inclined to interfere with impugned judgments and orders passed by the tribunal, as we have found no illegality, irregularity, or manifest error in the same. The writ petitions are therefore dismissed. Since the judgments and orders were passed by the tribunal in the year 2003, the petition should make compliance of the same and make available the consequential benefits to the opposite parties, including the intermination within a period of 3 months. We make it clear that those opposite parties, including the intervention opposite parties, who are appointed without training qualification and have already achieved the said qualification BD in the meantime, should be categorized as trained graduate teachers from the date of acquiring the said training and should be provided with all benefits attached to the post, my lord. Prior to my appointment, engagement in the school, my lord, appointment, I have qualified bid qualification, my lord. On 1/6/1994, I have appointed in the school, my lord. While I was continuing, at that time the headmaster sent a letter to the director for approval my post, my lord. During pendency of that approval, my lord, before the director, that director sent a letter to the headmaster, my lord. All the headmasters, my lord, the persons, those who are not, those posts whose posts are not approved, they should be treated as outsider, my lord. In the year 2002, that 2002 order was challenged before the learned tribunal on 1369/2003, my lord. That 1363, my lord, I am come to this order, my lord, by the tribunal.
So you worked only for 3 years.
My lord.
Just come to para 5.
Yes.
Of the compliance affidavit.
Yes, my lord.
Take the paper. It's still hunting. You don't seem to have a copy. Compliance.
5 minutes. That after dismissal of special petition before Honorable Apex Court, immediate steps has been taken for compliance of the order. According to the claim of the petition has been examined and found that she was appointed as an additional session teacher in Pubusai High School by the private managing committee and was joined on 1/94 and was asking till 29/9/97, then left the job, my lord. That which they have reflected that written, my lord, that is false, my lord. That appointment has not been taken in the tribunal as well as the High Court.
No. Where's Mr. Not taken? Factually, did you work after 29/9/97 in the school? Did you actually work beyond that date in the school?
No, my lord. Prior to,
sir, if you did not work in the school after that date, why is this government false?
I was continued, my lord. I have given documents how I was continued, my lord.
Continued in the school?
Yes, my lord.
Show us the document.
Yes, my lord.
Show us.
In the 99, your lordship,
Sir, after 97, we are on 29/9/97. Show
Yes, my
us
lord.
a document that even beyond 29, please listen to the question carefully.
yes, my lord.
Even after 29th September 1997, you were working in this Pubushahi school. Show
Yes.
us any document.
Yes, I am giving that. In my regional reply, I have given my lord. There are documents. I was appointed as examiner.
Sir, please do not go here and there. Try and answer the question properly.
Yes, my lord.
Hmm.
I am giving. Come to my 135 page, my lord. R by 2. R by 1, my lord. My annexure has been annexed, my lord. In the year 1999, my lord, 8/3/99, if I was not continuing in that school, how I will be appointed?
Sir, don't ask us questions.
My lord.
Don't keep asking
Yes.
us questions. We have asked you a question.
Sorry, my lord.
You answer the question, sir,
Sir.
after September 97.
Yes.
Please listen to it carefully.
Sorry, my lord.
After September 97,
Yes.
were you working in that school?
Yes, my lord. Because of I am continuing, my lord, on 8/3/1999, my lord, my name is Josnani Dasa, was appointed as assistant examiner, my lord.
Anyway, if you are satisfied with that answer, you be satisfied.
Yes.
All right. Anything else, sir? Anything else?
My lord,
What else?
my lord, when that order of 2002, when that order 2002 was challenged by the Lord and Tribunal, before the Lord and Tribunal quashed 2002 order. Thereafter directed, my lord, kindly peruse, my lord, the order passed by the Lord and Tribunal. Page 142, my lord. We therefore direct the respondents to approve the appointment of the applicants as additional session teacher in their respective schools. We further direct that the applicant, those who had possessed bid qualification at the time their appointment should be approved with effect from 7/4, my lord. And those who have acquired bid degree, subsequently their appointment should be approved from the date from which they acquired the said degree. The salary of the applicants, those who had possessed BD degree at the time of their appointment, should be given to them in the TGT scale from 7/4, and the rest should be the said school from the date they acquired bid degree, my lord. Those who are out of service, despite the interim order, should be permitted to resume their duties. All these exercises be completed within 3 months from the date of receipt of the copy of this order, my lord. In tribunal order, that is clear-cut reflected by, my lord, those who are out of service, despite the interim order, should be permitted to resume their duties, my lord. After that order was passed, I have represented before the authority, my lord, that the authority said that this order is in case of Vijayan case, my lord. According to this order, my case was disposed to, my lord, page 145, my lord. As this case are covered in the ratio decided in the aforesaid dash cases, we will direct the state respondent to implement the direction given by us in the aforesaid cases and take a decision in this regard within 3 months from the date of receipt of copy of this order, my lord. This order, my lord, the operative portion order of in Vijayan case, my lord, that according to that case, my lord, this order was passed, my lord. In terms of this order, my ratio decided in the Vijayan case, my lord. After that order passed, my lord, I made representation. After that order was passed, my lord, the order in 14895 in case of Vijayan, my lord, that was challenged before the Honorable High Court. Due to pendence of that case before the Honorable High Court, the authorities stated that the cases is pending before the Honorable High Court. After final of this order, your case to be considered, my lord. Thereafter, my lord, the case of Vijayan case, my lord, was disposed of by the Honorable High Court on 17/11/2005, page 151, my lord. The operative portion of the order, my lord, 154, my lord, In view of the we are not inclined to interfere with the improved judgment order passed by the tribunal, as we have found no illegality, irregularity, and manifest error in the same. The writ petition is therefore dismissed. Since the judgments and order passed by the tribunal in the year 2003, the petitioner should make complaints of the same and make available the consequential benefit to the opposite parties, including the intervention within a period of 3 months. We make it clear that those opposite parties, including the intervention opposite parties, who are appointed without training qualification and have already achieved the said qualification, BD, in the meantime, should be categorized as a trained graduate teachers from the date acquiring the said training and should be provided with the benefits attached to the post, my lord. Because of I was not made party in this case, my lord, government was filed the writ petition before the state. I have also filed a case before the honorable court, in which in the case, my lord, the honorable high court, the order in WBC 14032 of 2000 filed by me, my lord, the order was disposed on 59/2011 in terms of the order passed by the 14895 of 2004 order was passed, my lord. Thereafter, my lord, this order was challenged before the honorable Supreme Court, my lord. Which order passed? In my case, my lord, the honorable Supreme Court dismissed the case of this, dismissed the SLP petition filed by the state, my lord, as per R by 8, page 158, my lord. In this SLP, my lord, similar nature of employee, category of employee, have filed six SLPs were filed, my lord. Under my district, under the district of Khorda, two employees are filed. Similar category employee have filed the case against the two category employee. The SLP was filed before the honorable Supreme Court, my lord. My SLP is against me. SLP is 23191/2012. Against other two persons, those who have continued under the DO Khorda and then CF schools Khorda, my lord, 17386 of 2012, 17400 of 2012. After SLP was dismissed, my lord. After SLP was dismissed in the year 2015, my lord, on 4/8/2015, the government, as per Annexure R by 9, page 60, my lord, on 15/10/2015, directed to the Director Secondary Education in reference to the above subject, and I request you that on dismissal of SLP on 4/8/2015, it is decided to comply the orders of the Honorable High Court passed in the above mentioned writ petition immediately and file complaints affidavit before the court by 19/10/2015, my lord. The similar category of employee, those who have appointed in the school on the district education officer or the then CF schools, my lord, they against whom the state go so on Supreme Court, my lord, after decision of the Supreme Court, this order was complied. But in case of those persons, the district education officer, other persons, my lord, the Santosh Kumar Prusti and Sujata Mahapatra, they have got, my lord, more than 40 lakhs, my lord, and they have given posting order, my lord. Whereas I have not neither given posting order nor full amount, my lord. They have given posting order. I have only given, my lord, 51,296 and 76,94,6, my lord. They have stated that from 94 to 97 she was continuing, my lord. But they are stated that they are the outsiders, my lord. Even in that order, tribunal order, that is stated that those who are outside, they have to resume in the duty, my lord. All the employees are same footing, my lord. Similar footing, same place, my lord. Against 2002 order, they have challenged. After order was passed by the tribunal, that order challenged by before the honorable court by the state, my lord. WBC was dismissed. Against that WBC, that SLP was dismissed also. After SLP was dismissed in the year 2015, that issue was raised in the content that she is continuing in the 94 to 97, my lord. And in the Supreme Court, when they have filed the Supreme Court SLP, my lord, in SLP they are categorically stated, my lord, so far as the interim ground is concerned, my lord, they are stated, my lord. I have given My lord. Page 89, my lord. Grounds for interim relief, my lord. Supreme Court joda file in a SLB mela they have stated the impugned order is against the provisions of law and liable to be set aside. The state government will be compelled to make payment of an area to the respondent to the tune of approximately 20 lakhs, my lord. Tune of 20 lakhs. At that time, they have stated if this order shall not be stayed, the petitioner will to be tune of approximately 20 lakhs is entitled, my lord.
The next line is there are 6 such persons presently involved.
Yes.
Because all those persons' salary were considered. That is why.
No. Each person.
You just read just text line.
Yes.
There are 6 such persons presently involved. There are a large number of such teachers irregularly appointed like the respondent who would claim the same benefit from the petitioner.
Yes.
That is why that figure was.
Other employees, similar putting employee got more than 40 lakhs. More than 40 lakhs.
Because they have worked for that long.
But not worked for similar putting
Sir,
employees.
if with your kind permission, we both are sitting here, you want to have this conversation, you can have it anywhere. So
sorry,
from the corridor also you can
I'm
have.
so sorry. I'm so sorry. I'm so sorry.
That's it, sir. Anything else you have to say?
Yes, ma'am.
All right. We'll pass the order. The petition is dismissed. All right. We'll pass the detailed orders.
Yes.
Right.
Weekly list item number 38.
I'm from bank, sir. Comply order, sir. Order is complied.
None appears to the petitioner. Counsel of the bank claims that the orders have been complied with. The petition is dismissed.
Weekly list item 39.
None appears to Susan Roberts.
Weekly list item 40.
Item 40, I am appearing for the petitioner. It's a clear case, if possible, find my purchase was in 1989. Annexure 2, page 15. The lease has been cancelled.
Prior to the cancellation, he has purchased.
Yes.
Oh, I see. All right.
Remand.
On the short ground that you say the challenge in the present petition is to an order dated 24th September 2002 passed by the additional Tahsildar Bhubaneswar in WL case number 866 of 1972 under section 3 capital B of the OG Lease Act, cancelling the lease originally granted in favor of the vendor of the present purchaser. Paragraph on the short ground that the purchaser had also purchased the land in question by a registered CLD dated
Registered CLD 28/7/1989.
28/7/1989, that is much prior to the cancellation of the lease. And the impugned order was passed without notice to the present petitioner. The said impugned order is accordingly hereby set aside. WL case number 866 of 1972 is restored to the file of the additional Tahsildar Bhubaneswar and will be listed there on 6 September 2022, on which date the petitioner will appear along with the downloaded copy of this order. The additional Tahsildar will thereafter proceed in accordance with law and dispose of the said case within a period of 6 months thereafter.
Giving an opportunity to file a detailed objection.
Yeah. It will be open to the petitioner to file an affidavit of objection along with documents. Till such time, the interim order passed by this court such time, status quo as of date will be maintained.
Yes.
The petition is disposed of.
Item 41.
So when item 41, I'm appearing on behalf of the petitioner.
Yes.
Lord, the petitioner is the contractor and the opposite party number 3, that is the Orissa Construction Corporation, is the principal employer. And that has been pleaded by the workman himself in his application before the labor court. Now, before I go to the award, if I may just show the agreement between the petitioner and the corporation, which is at page 33. If your lordship will just look at that agreement.
This will take some time.
This will take about 15 minutes, 10-15.
Yeah, we'll just keep it at the end of the board. Pass over. Right.
Weekly list item 42.
Could your lordships just one prayer to your lordships?
Yes.
if your lordships can have it on some other day instead of the end of the board. Otherwise, your lordship may take it because after 2 o'clock, I'll be in personal difficulty.
Counsel, the petitioner states that he's going to be in personal difficulty today. List on 26th October.
Weekly list item 42.
None appears this was not possible.
Weekly list item 43.
Item 43, my lordship, permitted to withdraw with the liberty to file if cause of action arises, my lordship.
No cause of action, sir. It's 2013 matter. If the counsel, the petitioner seeks leave to withdraw the present petitions, dismisses withdraw.
Weekly list item 44.
44, lordship, it is handing over a objectionable site to a corporation, lordship. That is IDCO. And here state government to file a counter, lordship. We have received the counter of the IDCO. But it's necessary to file a counter by the
Yes,
state government.
Government has filed on 17th September 2019.
Copy the
Tahsildar has filed on 17th October 2019.
The construction or in an objection site, that is Gochar, lordship. It is not permissible.
No, you want to make a mini stadium, is it?
Lordship, instead of handing over to IDCO, it can be used for the purpose of the students' lordship. That is our, but they are going to construct in a Gochar land, which is the objectionable site, lordship. It's not permissible, may not be a mini stadium.
This is a 2013 petition. This you filed 9 years ago, sir.
Yes, lordship, but
Was there an
status of
interim order?
land is not yet to be changed, lordship.
Is there an interim order?
No, I think there is.
Interim order, there is no interim order, perhaps, lordship.
Then what have they done in the last 9 years? What has happened in the last 9 years, sir?
In fact, lordship, we are trying our best to leave this matter, but it wasn't.
No. What has happened in the land, sir?
In fact, lordship, that is I will obtain instruction. In fact, lordship, I have not.
Obviously, nothing has happened, sir.
Then lordship gave me liberty. If the cause of action survives, then lordship, I will approach.
Counsel, the petitioner seeks leave to withdraw this petition with liberty to file proper representation in the first place to the authorities if any fresh cause of action survives. This post office withdrawn with liberty is paid for. All right.
Weekly list item 45.
May I please your lordships? My lord,
Yes.
I may be excused, my lords. I am on BC, my lords.
Yes.
My lord, it's a case, my lord. The petitioner challenges Annexure 5, the order passed by the London Labour Court, rejecting my restoration application, my lords. My lord, facts of the case is like this, my lord. The petitioner establishment is a cement factory in Sundargarh, my lords. It was closed since 2005. And this workman opposite party, he filed after 4 years, claiming wages from 2002 to 2005, my lords.
What is the amount involved, sir?
Involved 2,50,000.
How you
Now, my
deposit
lord-
that amount, you straight away deposit, will restore it. You deposit that amount, will restore it, sir.
My lord, sir, may I submit, my lord, sir, because my lord, it's a closed establishment.
So that will be the cost of sending you back to the labor court, sending him to the labor court, all of that. You
No,
pay
no,
him this
some
2,50,000, he will close the whole claim itself.
Yes, my lord, some reduction, my lord.
No. You have got a stay from 9 years. You put
Yes, my lord.
2,50,000 simple interest at 9 years. This
No,
man
I'm
got not even 10
prepared,
rupees.
my lord, my
Sir,
lord,
this
I'm
man did
prepared
not
to
get
pay
even
some
10
cost.
rupees.
My lord, I'm prepared to pay some cost to the workman, my lord, because
Not
it's a case,
cost,
my lord,
not
on
cost,
past date.
sir. When did he go to the labor court? When did he go to the labor court?
Yes, my lord. Now, your lordship may kindly see paragraph 4 of the writ application, my lord.
1 minute. We'll find out.
Page 3. The workman approached on 4/2/2009. I have quoted the order, my lord.
Today is what, sir? It's 13 years.
Yes, my lord.
13 years.
My
He has
lord,
got
may
not even 100 rupees he has got in this period.
No. My lord, your lordship may kindly see on 4/2/2009, the application was filed.
Sir, if you're not prepared to pay this 2,50,000, we're going to not exercise a discretion. This is after all 227. We are not inclined to exercise discretion if you're not prepared to pay 2,50,000.
No.
Straight off.
If your lordship wants, because on one date, when it was fixed for
So
filing.
you've got to stay for 9 years. For 9 years, without paying a single paisa, you've got to stay.
My lord, that is there, my lords. But
Facing a money decree. See, you faced a money decree of 2,50,000 without shredding even 5 rupees. You got to stay for 9 years.
Yes, my lord, that has happened, my lord. But your
If you
lordship
just, if you had put that in a fixed deposit, how much will you earn, sir, by this period in 9 years?
double the amount, my lord. So if your
You have
lordship,
actually earned from this. You've earned from
no,
this.
my lord, what I submit, my lord, so I'll try to pay some amount deposit.
No. You're not doing anybody any charity. Let's be very clear here.
No,
if you want the luxury of litigation, you better pay 2,50,000.
No, your lordship,
Yes.
just for a moment, will see paragraph 4. That thereafter your lordship may pass the order.
Yes.
Your lordship may kindly see. 4/2/2009, I have quoted the order, page 3 of the writ petition.
Yes.
Received an application under section 33C2 of the ID Act 47 from the applicant praying to determine the money benefit due to him. Register it. It is a miscase. Issue notice to the opposite party fixing 17/3/2009 for filing show cause as to why the application under section 33C2 shall not be allowed. Send copy of application to the OP in the postal requisite filed by the applicant. Then, my lord, 17/3, the applicant is absent, workman is absent, the OP is absent. He has not filed the show cause despite registered notice served on him. Hence, the OP is set ex parte, my lords. My lord, where is the ex parte order, my lords, on the date of filing of the show cause, my lords?
Yes.
And my lords, it is not fixed for hearing, my lord. What I pray, my lord, I'm prepared to pay because it's a closed unit. Your lordship, I'll pay some cost to the workman. He is not getting anything. I'll pay some cost. Your lordship may target the matter, my lords. It will be disposed of, my lords.
So you
And
are not some cost, sir. You pay this entire amount of 2,52,000. We'll keep it in a. We'll ask him to take 50% of it. You deposit it in the labor court. We'll permit him to take 50% of it.
He's not our worker. He's so many things are there. We could not file the W.
All right. All right. If that's the attitude, then there's no reason to grant you any indulgence.
No.
Yes.
I'm not saying that. Your
Yes.
lordship
This is all luxury litigation. You come here on first day, you get a stay, and it doesn't come up for the next 10 years.
That is not your lordship.
No. It's everything is the court's fault, sir. Nothing is the litigant's fault. Everything is the court's fault.
No. I'm not saying that.
Everything is the court's fault. You get a stay first day, you enjoy the stay for 9 years, the fault is the court.
No, my lords.
Yes.
Pray, my lord, your lordship may pass order. I'll deposit that amount.
Yes.
Labor court may proceed. Labor court may proceed. That your lordship may say.
When will you deposit this 2,50,000 in this court?
Here, my lords, or before the labor court?
Whatever. When will you deposit? You show us proof of deposit, then we'll pass the next order. When will you deposit?
Then I'll take instruction, my lords. Your lordship may
we'll pass it over. I'm sure your client has a mobile phone, or he does not have that.
No. I don't. I have no connection with the client. My lord,
then how will you get instruction?
My lord,
how will you get instruction? If you have no connection, how will you get instruction?
My lord, the lawyer who has entrusted the brief to me from Raurkela, my lord,
he has a mobile phone, or he also has no mobile phone.
Yes, I'll talk to him.
1 hour is there. Pass over. We'll call it at 2 o'clock. At the end of this list, we'll call it. You get your instruction. Yes.
No. At 2 p.m., your lordship may kindly call this matter. I'll take instruction in the meantime.
All right.
Weekly list item 46.
Item 46, my lords, with the change in excise policy, it has become infructuous, my lords.
Counsel, the petitioner states petition has been rendered infructuous. It is disposed of as such.
Weekly list item 47.
May I please, your lords? The petitioner has referred this writ application challenging the hour of the learned CGIT Bhubaneswar. And the petitioner is working as a driver under the opposite party management on 9 January 2007 till 10th December 2007. And after that, the petitioner is not allowed to join in his duty. Subsequently, she was raised a dispute before the.
How many months, sir? 9 January to
11 months only, my lord. He crossed 240 days, my lord. And subsequently claim for regularization and his bonus. They have returns from the job. And subsequently disputes are raised. And finally the ID case was registered bearing number.
Let's come to the
15 of 2019, my lord. 2009,
Let's come to the findings.
In the finding, two issues were framed. First, whether the disputant workman was ever appointed engagement in any post of management company, and whether Sri S.K. Panda, deputy manager without any authority, has appointed engage the disputant workman for his own convenience. This is in the first issue. In the finding, it was in favor of the petitioner. In page 15.
So come to this page 15. Yes.
Yes, my lord. In the operating part, last for third line, my lord. Therefore, it is established that the disputant workman was engaged as a driver under the first party management. It is not a relevant fact whether Sri S.K. Panda, deputy manager, or the branch manager of the first party management has any authority to engage the workman or not. It was for them to answer that the disputant workman was not appointed by the first party management, but by Sri S.K. Panda, deputy manager, in his personal capacity. And for this, the disputant workman cannot be held to liable to any wages. This issue is decided accordingly. And the second issue, that regarding the continuation service, my lord, in the page 16, my lord.
Please read, sir.
My lord. Fifth line, that is against the workman, my lord. Though they have said that in the sixth line, the photostated copies of the port entry permit also not been established. The fact that the disputant workman had worked throughout the period from 9 January 2007 to 9/12/2007, the first party management has denied the fact that the disputant workman worked for 240 days in 12 calendar months proceeding, and earliest date of the termination. The burden to prove this fact lies on the disputant workman, and simply his oral submission doesn't suffice.
So what do you say? What is your submission now?
I'm not, man. Though the Xerox copy was filed, but that has not been executed, my lord.
It's all right, sir. So what do you have to say for that?
Therefore, I said to remand it back the matter.
No question, sir. Sorry. The challenge by the workman in the present petition is to an award dated 9th August 2011 passed by the Central Government Industrial Tribunal cum Labour Court Bhubaneswar in ID case number 15 of 2009. Paragraph, the dispute referred to the Labour Court for adjudication was as under. Take from page 10, top. Paragraph, two issues were framed by the following two issues were claimed by the Labour Court on the basis of the evidence, pleadings of the parties. And take from page 12, para 5. While on issue number 1, the Labour Court held in favor of the workman. On issue number 2, it found that he had not placed any documentary evidence to show that he had been continuously engaged by the management as driver between 9th January and 9th December 2007. The witness examined by the workman, Dibakar Panda, in his cross-examination stated, open quotation, I cannot say the date of joining and date of leaving of the disputant workman, unquote. Further, the Labour Court found that only a photostat copy of port entry permit was furnished by the workman. This in no way showed that he had continuously worked for 240 days in the 12 calendar months preceding the date of termination. Paragraph, the above findings of fact have not been able to be overcome by learned counsel to the petitioner, who merely submitted that the workman should be given one more opportunity of producing evidence by the matter being remanded to the Labour Court. Full stop. The court is unable to agree with the above submission. Full stop. Sufficient opportunity was given to the workman to prove his claim, which he has failed to do. Consequently, the court finds no error having been committed by the Labour Court in rejecting the claim of the petitioner workman. The petition is accordingly dismissed.
Obligement.
Quickly list item 48.
Item 48, my lord, I am appearing on behalf of Mr. B.K. Naik. We have already sought for up-to-date information regarding the instruction from the secretary of the cooperative society. Because of election, there is a change in the secretary, and we have already sought instruction. So this make me kind of agenda some other date. my lord.
Who's appearing for the other side?
I'm appearing on the other side, my lord. If your lordship will permit me, if your lordship, I have two submissions to make. On 16/4/2011, the award is passed. They do not file their written statement. They do not appear before the labor court. Subsequently, they file an application for restoration. Again, the restoration application is listed. They do not appear. The restoration application dismissed. They challenge that restoration order in a writ petition before your lordships in 2013. In 2017, they amended that writ petition and challenged the mean award.
Okay. So the net result is anyway they have to appear before the labor court then.
No, my lord, the award has been passed.
What's the amount awarded?
The reinstatement and 30,000 as in lieu of back wages.
30,000.
At no stage of the proceedings they appeared before the labor court, not even after filing the restoration application.
Cashier, some clerk. So what is the age of your client now?
He is now 57.
Would you be willing to explore the possibility of settlement through mediation?
Yes, ma'am.
That may be better because he's got only 3 years left. Let them pay him a lump sum.
Lord, in any view of the matter under the ID Act, I'll be eligible of the compensation, and from the date of the award, I'll get the full salary.
So you can calculate all that and negotiate in the settlement.
Could your lordships adjourn it by a week or so that we can take instructions?
No, just why don't you use the time to attempt mediation? Where is your client? He's in Puri only, so he can easily come for mediation.
He's in Puri.
Puri, ma'am.
You see, the court is of the view that the party should attempt settling the disputes through mediation. The representative of the petitioner and the opposite party will appear before the High Court Mediation Center at 3:30 p.m. on 11th August.
Very well.
11th August.
My lord, the name of Mr. B.P. Satpathy may kindly be removed from the court.
All right. The report of mediation be placed in record by the next date. 17th August.
Very grateful.
Oh, sorry, we'll have it on 24th. We'll give it some more time. 24th August. All right.
Very grateful.
May I please your lordships. My lord, a somewhat of Bevondas proceeding was initiated by the collector, my lord, and the land was settled in favor of me, my lord.
What is the date of settlement?
93, my lord. 13/8/93, annexed 2, my lord. Page 20, my lord. And
no, the order of the Tahsildar is 38/93.
My lord.
So you're challenging that, correct?
No, my lord.
No, I have not challenged that.
The appellate order at Annexure 1.
Appellate order.
Page 20.
Oh.
But during the, my lord, what happened in this case, my lord, after settlement of the land, my lord, again in 2001, my lord, the Tahsildar again issued so much of case proceeding, 2001, my lord, Bebonso case number 117 of 2001, and sent the matter to the sub-collector for confirmation, my lord. And while the Tahsildar, my lord, has settled the land in favor of the Devotar, my lord. And due to such dispute, my lord, I have filed a civil suit, my lord, before the court below, my lord,
and civil suit decree in favor of me, my lord.
And that decree is final.
My lord. No, my lord. That decree, my lord, subsequently challenged by the Devotar department in first appeal, and first appeal was in favor of them. And I have challenged in second appeal. This is pending before your lordship.
Where is that second appeal number?
My lord, number is 605 of 2014. Your lordship may kindly both the matter may kindly heart together so that.
No, but that is before a single judge, correct?
My lord.
Why is this before a DB, this kind of matter?
It is by the OEA appeal, my lord. Orissa state abolition.
No, this is old matter also, division bench matter and old matter.
List along with RSA number?
My lord, 605 of 2014.
605 2014, or you list it after that is decided. I think that's better, no?
My lord.
Mr. Mandi, let that be decided
Yes,
by a single judge. You say it is stated that against an order passed by the First Appellate Court in favor of the opposite party number 3, against in an appeal against the judgment and decree dated 31st July 2008 in civil suit number 102 of 2003 filed by the present petitioner. No, by the father of the present petitioner. The regular second appeal number
605 of 2014.
605 of 2014 has been filed in this court, which is stated to be pending. This writ petition will be listed after the decision in the aforementioned RSA number 605 of 2014.
The interim order to continue.
Obviously, sir.
My lord.
The memo is taken on record. The petition is dismissed as withdrawn.
My lord, here the third parties challenged a settlement in my favor in revisional forum. That revisional order is annexed under Annexure 1, my lord. My lord, my settlement was made in the year 1998. That your lordship can find from the appeal memo. The appeal memo is Annexure 2, my lord. They are challenging the settlement made in the year 1998 in lease case number 140 of 1998 was challenged. My lord, 2010 is the revisional court. They filed a revision. No limitation petition was filed. The revisional court cancelled my lease on 2 grounds. Your lordship will see that it is observed from the report of the RI such and such submitted on 17/9/98 to the Tahsildar Rampur. The LCR is not clear and not in consonance to the lease principle. RI has not submitted his report after proper inquiry. The report of the RI, in my observation, is bad in the eye of law. The RI would have submitted a report with proper inquiry. The lease might not have been granted. As such, Sagar Sahu has concealed the fact that he is a landed property, cultivable land, homestead land at the time of application of grant of lease. So it is noteworthy that he has defrauded the Tahsildar to obtain the order of the lease. Hence, the case law cited such and such is ignored. The court, on the other hand, an ample jurisdiction to set aside the order of lease under 7A3 of the OGLS Act. My lord, I have got a report. Your lordship will see that report, which was called for, my lord, Annexure 4, wherein it has been endorsed by the inquiry officer that it is lying vacant and not in possession. Your lordship will see reported, and therefore submit parawise report for perusal of the honorable collector, where there was a recommendation for grant of lease. First of all, my lord, the revision could not have been entertained without a limitation application. 98 settlement lease, 2010 they file a revision, private parties. No limitation petition has been filed. And the court below has not considered the limitation ground.
What do the opposite parties say on limitation?
And in a civil suit filed by them, they have lost injunction.
Civil suit is that is separate, is my lord, but so far as present petitioner is concerned, he has not. My lord, kindly see paragraph 2 of the.
What do you say on limitation,
Annex 1.
sir? What do you say on limitation? This was filed after 14 years.
Limitation, my lord. So I have not filed any limitation petition, lord, but so for OGLS as concerned, lord, section 2 subsection 2 has not been complied with. My lord. He is not entitled to get any land, my lord, because
No, unless you first satisfy limitation, what's the question of going into merits?
is admitted fact, I have not filed any limitation petition.
Then
by virtue of a petition under section 7A, the
7A itself says, sir, 7A3, just come to 7A3.
Yes, ma'am.
It's set out in the petition, I think.
$90 days.
Your own counter affidavit says, second page, 7A3.
Yes.
No proceeding shall be initiated after the expiry of 14 years. Was the revision petition filed within 14 years?
Yes, within 14 years it is.
Mr.
98 is the settlement. 2000 they have filed the revision petition. 2010.
This
Sir,
is
so
within
that's within
14
two-
years.
Within 14 years.
But 7A says 90 days.
Well,
My lord, if it is applicable, this 14 years, my lord, they could have, if the state would have questioned, let us accept that the state would have questioned. My lord, here state has not questioned the revision. The private parties have filed the revision petition. And for private
So
parties,
7A3 is not, this is not under 7A3.
No.
Under what provision is this revision?
My lord, they have filed revision under 7A.
7A3, lord. Kindly have class, lord, annex 2.
7A3, they say.
No, that's not so moto. 7A3 is so moto.
So moto. That is a so moto power.
Okay.
My lord, 7A3, the collector may its own motion or otherwise call for examining the recording of any proceedings in which any authority subordinate to it has passed an order under this act.
Correct. This is not a suo moto.
State has not moved, my lord.
Correct. Correct.
Private opposite parties have moved.
Correct. Correct. So this has to go on that short ground, sir.
Lord, sir, may remind the matter.
For what? The challenge of this present petition is to an order dated 20th December 2012, passed by the collector, Suvarnapur, cancelling the lease in respect of plot in Khata number, land in Khata number 339, plot number 315 of an area of AC 0.025.
My lord, kind of glance the 7A for a moment, lord.
Yes, yes.
My lord, the revisional the collector may revise any order made under subsection 1 or subsection 3 of section 3 by a subdivisional officer or revenue officer. A revenue divisional commission may revise any order made under that section by the collector if any application, that is the important, lord, that if any application made by the aggrieved person within a period of 90 days. That is 7A says, lord. But provided the collector provisional commission, as the case may be, may admit an application under this section after expiry of the opposite period 90 days.
What do you want to say? You're just
Yes.
interrupting for nothing.
Yes.
What was that? Of AC 0.025 of village Tamamura. At the instance of opposite parties 2 to 5 in revision case number 1 of 2010. Paragraph. The admitted fact is that the above lease was granted in favor of the petitioner by an order dated Sorry, what's the date of the order, please?
Well, that is not there, neither in the order sheet. Your lordship will see. It is not there, he has not mentioned. But it is of the lease case number 140 of 1998.
The lease in favor of the petitioner in respect of the above land was granted in lease case number 140 of 1998 by the Tahsildar Rampur. No, but how do you know then it's not within 90 days and without 90, beyond 90 days? How do you say that unless you know the date of the lease?
It is not even mentioned in the order.
Even in the impugned order, limitation point is not discussed. That is.
Please take the name. Case everywhere, my lord, case number is given there. Petitioner to the case. Petitioner.
So, Mr. Bose, this limitation will hinge on the actual date of grant of lease.
Well, I'm sorry, I'm also not aware of the date.
There is no annexure to that.
So, can you find out, Mr. Bonti?
No, there is absolutely no.
No, you'll have to find out from the lease case number. You'll have to call for the record and see it.
That if your lordship will order, I will.
There's a report, parawise report, let's see, of the Tahsildar.
My lord, that is at annexure 4, my lord. Yes, my lord. Your lordship can see at internal page 2, my lord.
Yes.
It is revealed from the issue of proclamation by number 146 in lease case number 140 of 1998 dated 9/9/1998.
Right.
I'm sorry, my lord, I could not point it out earlier.
All right. You see, what is it? In respect of which a proclamation was issued on 9th September 1998. Paragraph. It is stated by opposite parties 2 to 5 that they purchased the suit land from the original owner under registered seed deed on 22nd June 2010. When they became aware of the grant of the aforementioned lease in favor of the petitioner. Paragraph. Thereafter, the said revision case 1 of 2010 was filed before the collector. Under section 7 bracket A of the OGLS Act. Paragraph. At the outset must be noted that although according to opposite parties 2 to 5, the revision petition is preferred under section 7 capital A bracket 3. No, but Mr. Bose, this 7A3.
Yes, ma'am.
Says that the collector may on his own motion
Yes,
or
my lord,
otherwise.
collector may on its own motion, if my lord,
Or otherwise.
or otherwise, call for an examine.
Yes.
My lord, here question is, it's a suo motu proceeding. If the state authorities would have challenged the lease, my lord, the matter would have been different.
No, or otherwise means what?
Examine any proceeding which authorities or otherwise call for and examine the records of any proceeding. My lord, the first
on its own motion is one part, or
Yes.
otherwise meaning it could be by anyone else
Even
filing that.
at the instance of any agreement.
But 7A1 says the collector may revise the order by subdivision authority and division may revise any order of sub-collector if an application is made by agreed person. The agreed person is not there in 7A3, my lord. Agreed person is not there in 7A3.
Actually, there was another 7A3 because this is a substituted from 2013. There must be another provision when this 2010 matter was filed. No, this revision petition was filed 2010. And this is substituted. Do you have an older 7A3?
My lord, I have got this substituted under F81 book. 81, that substitution is there in my book. The previous one, I don't have. I've not brought that.
No, this one which we have, the footnote says substituted by
White Orissa Act 1981.
What you have, is it?
Yes.
And that says or otherwise.
Or otherwise.
So that or otherwise could mean even by an application.
But if 7A1 provides agreed person, the word aggrieved person is not there in collector, in the power under 3.
No, because it's about mistake of fact, fraud or representation. That those grounds are not there in 7A1. Just see this. That's why it's different.
My lord, even if so, my lord, if he has also moved, at least he should incorporate in the body of the application or file a separate application for limitation.
No, why?
It is 14
There's no
years, within
limitation.
14 years.
It's only 14 years.
There is no limitation in that way.
In fact, after 2013, the limitation has been removed. There's no limitation after 2013.
But this is of 2010.
So that what is there in that their petition reply, just see the counter affidavit. That's the actual provision at the relevant time.
Your lordship may kindly see the petition itself, which was filed before the revisional authority.
Correct. It's within 14 years.
But can they invoke 783? That point your lordship may decide. Because once the provision is there for them under 781.
No. That is for general. This is on the question of mistake of fact or fraud or misrepresentation. And they say in the body of their petition, that's how I noticed it. Just come to this annexure 2.
Yes, my lord.
You will see that the petition itself is filed under 783.
My lord, mere writing of a provision, can he get that power under 783?
No.
He will get only under 7A1.
No. 7A3 is what is invoked. We have to see whether he could have invoked 7A3.
Yes.
The word is or otherwise.
Yes, ma'am. But where is the fraud he has stated?
No. He says that it is a mistake of fact or owing to a fraud. That will go to the... So we are not on limitation now.
So that is a question of merit.
That's why the inquiry is held by the Tahsildar and then he finds out...
And there is a positive finding that this lease was granted in an irregular manner.
Correct.
That is not a suo motu power. My humble submission, subject to what your lordship says.
No, the word or otherwise means...
Yes, or otherwise is there. But or otherwise, can it be equated with an aggrieved person?
Yes, that is.
If your lordship holds that, I have no case.
In fact, it could be any person, but here definitely it's an aggrieved person because he's purchased the same land under a registration.
Any person, what is also not there, my lord?
No. It's wider.
Or otherwise. Or otherwise means, I would like to say, my lord, that all otherwise means when the collector examines a record.
No, that is again on his own motion.
Own motion.
And when you have to give meaning to or otherwise. On his own motion or otherwise.
That your lordship may decide. That portion.
Or otherwise gives a broad power.
Correct.
To invite the objections from any corner, from any person.
Correct.
Then 7A1 has to be given a go by, my lord.
No. That is there. That is a general law.
That's not being invoked. If it is invoked, then we will see. That's a general power of revision.
Mere writing of a provision of law.
He passed. No. He in the body of the petition, he makes up the ground that this was without any inquiry, and it has to be inquired into.
He says proper proclamation inviting objection was not conducted. Then he had to...
No, and he's having house property elsewhere, he says.
He purchased...
He's not a landless person.
But I am having house property, that is not one aspect. It is not a settlement. It is not a settlement under the OPLE Act.
It may not be, but this
is a lease. I am seeking a lease from the government.
No, but it's an order passed in this act only by the Tahsildar.
There is no dispute in that. Only thing is that whether he is entitled to such a lease, having land otherwise.
Exactly.
The report is contrary to what is the finding.
And
if the report is contrary, then he should distinguish that report was wrong. He relies on the report. He calls for the report. I have given the entire order sheet. He calls for the report. The report is otherwise, but he passes the order otherwise.
My lord, your lordship is to answer the submission made by the petitioner that whether it is coming under section 7A3 or not. By my submission before lordship is that, or otherwise also empowers anybody to invoke the power under section 7A3 in case there is a fraud or misrepresentation. Here is a case where the learned collector has, in the impugned order, has categorically held that there is some irregularity, there is some misrepresentation, and he is not a landless person. These are the classic example by which the lease could have been cancelled.
No, but what does the report actually say of the Tahsildar?
Yes, your lordship must see the report. Your lordship will see Annexure 4, Para 3, as prayed for granting lease in favor of OP Sagar Sahu is illegal and suppressing the fact that and on the ground of settlement is totally incorrect. As such, verified some relevant facts and materials, not suppressing the matters, it has been gradually maintained the record, the knowledge of the higher authority concerned. Thereafter, Your Lordship, the petitioner endorsed in the petition that there was absence of proclamation inviting objection to the proper inquiry, not in the manner prescribed. It has been revealed from the issue of proclamation by such and such, dated such and such, with authenticated by the deed and Tahsildar and due service of general proclamation in conspicuous place of the said village, and no objection filed by any general public in the period of objection. Reveals from the plain copy that plot number 315 situated between public road and plot number 316 of Moja Tamura as averment made by the petitioner in revision case. So also the petitioner has purchased the plot number 316 by registered deed dated 22/6/10. There is no any other passage way to enter plot number.
No, see, the earlier thing is that earlier paragraph, just see in that report itself.
Yes, ma'am.
He finds,
it has been revealed that issue of proclamation.
No. Very first paragraph, the earlier page 1. Accordingly, the RI is reported with inquired bearing khata number so and so, plot number 315. It's recorded in.
Yes. Accordingly, verified the case record and found there was instituted the case for grant of lease in favor of the lessee. The lessee has OP of the revision such and such, and the case is sub judice before Collector Sonpur. As such case instituted in the time of my predecessor of the then Tahsildar Rampur, and passed an order earlier in favor of the lease, and the same was approved by the sub-collector Sonpur and issued patta as given below. Now I verified and intimated the present RI such and such by office letter number such and such, dated such and such, for inquiry and report. Accordingly, RI has reported an inquiry being khata number such and such, recorded name of Sagar Sahu.
Para 2 is important.
Yes. As prayed for by the advocate for the petition and revision case, the present OP Orissa Sahu, having landed property as prayed for, accordingly verified and found that khata number such and such is there in name of Orissa Sahu.
So this is why he's saying you're not a landless person, because these lands stood in the favor of your father.
Yes. There are other brothers, and it belongs to the entire family. It belongs to ancestors.
But then you don't become landless. So the question is, you also get a share of that property.
Yes, I get a share. But whether
so unless you're a landless person, this lease should not have been granted in your favor.
It is not always that a landless person has to get it.
That is the cardinal.
Your Lordship may kindly see paragraph 2E of the OGLS. Landless. Landless definition set OLR actor.
It has to be a landless person for settlement. What is the provision under which settlement happens?
My Lord, may kindly see what is the definition of landless person in OPLE Act. OPLE Act says landless person means a person the total extent of whose land, excluding homestead, together with the lands of all members of his family who are living with him in common mess, is less than 1 standard acre, and whose total income of all the family members of the family who are living with him in common mess does not exceed 6,000 rupees. This is OPLE Act. Landless person means
under OGLS Act.
Yes, I'm coming to it. Person means a person whose total extent whole land, excluding homestead, together with the lands held by the family who are living in common mess, is less than 1 standard acre. That is also in the OGLS Act, my lord. So a person whose entire property will be less than 1 standard acre.
No, section 3 may kindly.
And standard acre has been defined under the OLR Act. What is a standard acre?
Section
So these aspects, my lord, has not been considered by the learned revisional court. He has said that because I have land, I am not entitled to settlement. My lord, he has to discuss these provisions, which is my grounds of challenge in this writ application. The OLR says what is a standard acre. OPLE vis-a-vis the act under the OGLS is same.
3.3. Section 3.3.
And Rayat. He's not a Rayat.
Plus 3,
Yeah,
small
3,
b.
3.
So, small b.
Yeah.
My lord, this settlement of land under this section shall be made in following order of priority. This is one aspect. Question is, my lord, whether I am governed under the provisions that whether I am falling within the definition prescribed under section 2B Roman 2, 2B.
In absence of persons belonging to this. Does he fall under D also? Rayat. He doesn't fall under D.
Yes.
No, is he a Rayat? I don't think so.
Who personally cultivate not more than one standard of land.
No, I don't think he was a cultivator.
No, that is not the case. My lord, your lordship may kindly keep it in mind that this is under the OGLS. We are dealing with OGLS Act. So the impugned lease is under the OGLS Act. So we have to strictly follow this section 3.
Yeah.
Whether he is coming under any of the priority of section 3 subclause 3. Section 3 subclause B, 3 subclause small b, any landless agricultural laborers. The very requirement is that he should be a landless person.
No, one of them. One of the categories is that.
That is one of the other categories he is not coming.
No, E, in the absence of person belonging to any of the foregoing categories, any other person.
Yes.
So, how do you know there is no, in the absence of persons of any other categories, that it can't be that?
That can't be. In that village, there is no other person. We cannot presume that. That is my responsibility.
Correct. He's not that. So he's not even claiming that. So under what category in your original application for lease, one will have to see what did you actually say?
That is perhaps there.
State record can.
The impugned order says he did not disclose that he has no other land.
No, person includes.
You were granted this on the ground that you were homeless and landless. That comes from the impugned order. The second or third line. So it is under category 3B.
3B. Yes.
No? See, even this person.
He is not a landless or homeless person.
There's no limitation, not of this also.
Limitation, your lordship has already verified. It is not coming on the way.
Sorry, Mr. Bose.
But one thing your lordship will see, whatever your lordship will decide, I have nothing to say on that. Question is, can he ignore section 2B Rome 2 of the OGLS Act? Let us accept, my lord, it is an OGLS Act. Your lordship may not look into OPLE. But OPLE is a contrary provision to 2B of the Act. 2B of the Act says means a person who any person, the total extent of whose land
No, but you've
excluding
not covered
homestead.
the category. You've applied in the category of landless, homeless.
My lord, yes, that person has been described. How is landless has been described here, my lord?
No. Here, this kind of a person is very different. There, you hold some land, then you apply whether it's less than 1 standard acre and all that. That's very different. Here, you've applied as landless.
As a landless person.
Yes.
In the
You not
category
even
of the
disclose
landless.
that you have other land. So the question doesn't even arise. We'll pass the detailed order dismissal.
All right.
Weekly list item 52.
My lord, here, my lord. Earlier, I filed a small date chart, which is relevant for the purpose of this case, where some dates are relevant. Let me place that date chart, my lord, my lord.
The workman has died, sir,
That is
already.
in the record, my lord.
The workman has already died long ago. The
Yes, ma'am,
workman
that-
died way back in 1997.
That is,
You're still chasing the family.
The legal heir has been substituted, and
I know, but why should the legal heir
legal
suffer,
heir
sir?
appeared before the labor court, and the award has been passed
In their favor?
Yes, ma'am.
Ah, that's okay, sir.
That was substituted, and she has contested in the labor court.
All right. Have you deposited
The
any
date
amount
chart
here?
is relevant in this case, my lord. That is in the record, my lord. That was filed on the April 2021, my lord. May I place that?
Yeah.
Yes, my lord. That is on 19 June 1989, the workman was charged sheeted for misconduct of carrying passengers without ticket, and he was sought for explanation. In 10/5/1991, the inquiry officer submitted the inquiry report after duly conducting the inquiry, wherein he was given finding establishing charges against the workman. On 30th August 1993, the workman was dismissed from service after paying his dues in compliance to Section 33(2)(b) of the ID Act. In 30th August 1993, immediately after such dismissal, the management filed a miscase number 34 of 1993 before the Industrial Tribunal under Section 33(2)(b) of the ID Act for approval of the action taken against the workman. On 27/12/1993, the workman complained before the conciliation officer alleging illegal termination from service without duly conducting the domestic inquiry. In 1995, the workman filed a miscase number 1 of 1995 under Section 33A of the ID Act, alleging violation of Section 33(2)(b) of the ID Act. In 1996, the conciliation submitted the failure report to the government. Then the government referred the dispute to the Industrial Tribunal under Section 10(1) of ID Act for adjudication dispute, which was registered as ID miscase number 54 of 96. That is the present dispute before my lord's mind. Then in 17 February 1997, the workman died. Then on 21/2/1998, miscase number 3493 filed by the management under Section 33(2)(b) was withdrawn since the workman died. Miscase number 1/95 filed by the workman remains pending, my lord. That is the finding in the court, my lord. In 3/19/2012, Industrial Tribunal passed the award in ID miscase number 54/96. In that case, the Land Tribunal has framed 3 issues: whether the domestic inquiry conducted against the workman is fair and proper. Next issue is whether the dismissal of the workman from service with effect from 30th August 1993 is illegal and or justified. Then third issue is to what relief, if any, the workman is entitled. The Land Tribunal, while answering the preliminary issue number 1 in para 7, 8, 9, and 10, has answered the issue that the domestic inquiry was fair and proper. Then in Land Tribunal, with regard to the other issues number 2, has held that in para 12 that the order of dismissal from service is found to be justified.
Yes, sir.
Yes, my lord.
My lord, on behalf of HN Mahapada, I am offering for the opposite.
1 minute, 1 minute. Let's just see if he makes out a case. Yes.
So far my submission is that, so the reference is concerned under section 10(1), that has been answered by the labor court. That dismissal is justified. Your lordship, I'll take your lordship to award of the labor court.
There's a very neat legal point here, sir.
Yes, my lord.
They had filed an application way back in 95 for violation of 33(2)(b). That was not decided, that was kept pending.
That is pending, my lord. That is pending.
On that, now the labor court has decided that there is a violation of 33(2)(b).
But my submission is that
yes,
that case is pending, my lord.
No. It's still not pending, sir. Now it's decided. That's how you have come here. You are here because that was decided against you.
The question before my lords is,
yes,
my lord, running page 20, there is a finding of the labor court with regard to reference made by the government, my lord, under section 10. The dismissal work from this is found to be justified. Your lordship can return to section 10(4). Section 10(4) of the ID Act. After answering the reference, can the labor court proceed further, my lord? That is...
The award is not published, sir. The award is not published.
Yes, my lord. The reference is whether the termination is legal and justified. That is
correct. But the award is not
that
published.
was made by the government.
No, the award is not published.
Award of termination. Yes, my lord. This is the award of termination. This is the question of termination. And after conducting disciplinary proceeding, and the labor court answered that the domestic inquiry is fair and proper, then proceeded further. That is since that
para 14 onwards, sir. Para 14 onwards, it discusses this miscase 1 of 95.
Those facts beyond the terms of reference. That my submission is that since section 10(4) prohibits that labor court cannot proceed further.
But this ID case is pending.
ID miscase, that has no...
It is a miscase in this very case, sir.
No,
it's not some other case.
That is the problem. I know this is not the very case.
What else case is there? It is this very case that all your applications are filed.
This is the reference case. So far the ID miscase violation of 2B, that is pending, my lord.
No, but it is in this very case. It's no longer pending, sir. Yes, now come to para 14. He's taken it up.
Yes, my lord.
In the interim award, he's decided that application.
No, interim award, my lord, kindly have a...
Not interim award, sir. Come to para 14.
Yes, my lord.
Of this very award.
Para 14, I am placing, my lord. Now it is to be considered as to whether the observations made in Jaipur JSBW bank case are applicable to the facts of the circumstances of the case in hand. It is not disputed by the parties that on the date the impugned order of dismissal was made by the first party, an application under 33(2)(b) of the Act was filed before the tribunal seeking the approval of the order of the dismissal on the ground that as on the date of dismissal, ID case number 19 of 89 was and 21 of 89 was pending disposal before this tribunal, in which the deceased workman was concerned workman. The management's application that is 33(2)(b) of the Act was registered as ID case number 34 or 93. It is also not disputed that the deceased workman had also filed an application on 33A of the Act, registered as ID case number 1 of 95, alleging that he being concerned in the pending industrial disputes and the alleged misconduct being connected with the pending dispute, the management ought to have obtained express permission from the tribunal, and the permission which do not been obtained by the management contravenes the section 33(1)(b) of the Act. Next, my lord, para 15. It is ascertained by the second part is that the management withdraw the application under section 33(2)(b) of the Act, and the management takes further stance that the case on the application of 33(a) of the deceased workman has been dismissed, but the parties have failed to adduce any documentary evidence in support of their respective stance. So this tribunal, my lord, can have marked this one. So this tribunal has obtained the concerned case records from this record room and found out as to what happened to both the proceedings. On verification of both the records, it is found that during pendency of both the proceedings under ID Miss Case number 34 of 93 and ID Miss Case 1 of 95, the workman have died. His widow was allowed to be substituted by the order dated 27/10/97. On the same day, this tribunal passed the order in Miss Case number 34/93 that both the Miss Cases is be heard analogously. On 21/2/98, the management filed a petition to withdraw its application under 33(2)(b) of the Act on the ground that the workman was already died. Though there was objection against the such withdrawal, this tribunal allowed the application and dismissed the Miss Case number 33 of 93 as withdrawn. However, the order passed whether the order, other Miss Case number 1 of 95 should proceed. The parties did not take any steps on the other in the other Miss Case, that is 1 of 95, and therefore, till date, no order has been passed on the application under section 33(2)(b). So for this Miss Case number 1 of 95 under section 33(1), that is still pending.
No, it's over, sir. That is exactly what is deciding now.
That is
that is exactly what is deciding now, sir. Please continue reading now.
That the parties did not take any steps.
Yes.
In the other Miss Case number 1 of 95.
Yes.
And therefore, till date, no order has been passed.
Now he is passing that order. After noticing all that, he is now passing the order.
On the application under section 38.
Yes.
So no order has been passed in that case.
Till then, sir, till he decided, no order was passed. Yes. Now he has passed the order.
This is not the case, my lord.
Anyway.
This is the,
it's all right,
this is the reference
your
case.
submission. All right.
This is your reference case.
All right.
This is another case.
All right. All right.
So your lordship can have done. This is the reference case that has been registered as ID case number 54.
Miss case will
that is a
the word miss means what? When somebody says miss case means what?
But the labor court has not discussed this case.
Sir,
what
is the meaning of miss case? Miscellaneous case has to be in some main case. Miscellaneous case has to be in some main case.
Yes. Miss case. So in the hour.
Miss case does not exist separately, sir. Miss case is in this very main case.
It's a separate case, my lord.
Anyway.
My second point is, my second point is, even let us assume that that is in violation of 33(2)(b).
Yes.
Can it be automatically held that the proceeding of dismissal is automatically?
Yes, absolutely.
That I have referred to one judgment, my lord, that is 1971 Supreme Court, 2417, that is the copy I have already submitted, my lord, that is in the record, my lord.
Where is that?
Already I have submitted, my lord.
All right.
Paragraph 9, I will place that.
All right.
Paragraph 9, my lord.
Yes.
The scope of section 33 and 33A was examined by this court in several cases, to some of which we shall presently refer. Section 33(1) has obviously no application to the facts of this case. Section 33(2) relates to the dismissal, discharge, etc. of the workman for any misconduct not connected with an industrial disputes during the pendency of any conciliation proceeding before a conciliation officer or board or etc. unless he had been paid wages for 1 month and an application has been made by the employer to the authority before which the proceeding is pending for approval of the action taken by the employer. Section 33A enables the workman who has been punished by dismissal or discharge, etc., to make a complaint in writing to the labor court, tribunal, or national tribunal when an employer contravenes the provisions of Section 33 during pendency of proceeding before the labor court, tribunal, or national tribunal, etc. If such a complaint is made, the labor court, tribunal, etc., is to adjudicate upon the complaint as if it were a dispute referred to or pending before it, and in accordance with the provisions of the Act, submit its award to the appropriate government. In other words, when the conditions laid down under Section 33A applies, a workman who is punished as mentioned therein does not have any weight for reference of the industrial disputes for an appropriate authority under Section 10 of the Act for adjudication of the dispute, but can himself prefer his complaint, which is to be treated in the same way as a dispute under Section 10. Thus, this section does not lend themselves to the construction that as soon as the labor court, tribunal, etc., finds that there has been violation of Section 33, it should award reinstatement.
Here, there's no reinstatement anyway, sir. The man has died. The only thing the labor court is doing is giving him his family, some paltry 75,000. That's all.
I'm not on that way.
If you're not on that, don't be on that. We'll leave everything open. Let them get that 75,000.
But labor court cannot say that.
So you don't want to give them that even 10 rupees of that 75,000, correct? All they have got after a man died in 1997 is 75,000 rupees. Until date, they don't even have it in their hands.
I'm not standing on that way, man.
If you're not standing, we will release this amount, leave all your questions open. If you're not standing. If you're not standing on that, we don't have to waste our time. We'll record your statement, let that 75,000 go to that family, and your questions of law can be open. No other relief has been granted. We'll pass the order. The petition is dismissed. Yes. The amount will be released forthwith.
Weekly list item 53.
My lord, item number 53, my lord, not press.
Counsel, the petitioner states he does not wish to press this petition.
It is infructuous, my lord.
All right. Since it is infructuous, it is disposed of as such.
Weekly list item 54.
54, Lordship, no instruction. I have no instruction.
No instructions disposed of as
We'll say that if cause of action arises, then I can.
No.
Weekly list item 55.
Well, item 55 relates to an entry tax matter. It's an entry tax matter, 10-3 assessment. If you permit, is a registered dealer who is actually manufacturing sponge iron, steel billets, and TMT bar structure steel. He has also got a captive power plant. But if you kindly look at the order that has been passed on 10-3.
So this is an appealable order, sir.
Sir, one thing I would like to say, there is no jurisdiction to pass such an order. And you kindly see beyond the power and authority. If I can satisfy your lordship will say, go to appeal, I'll go, madam. So kindly see 10-3. Kindly
OET Act.
10-3, madam.
OET Act.
Yes, madam.
Yes.
Here actually under section 9, self-assessment was made. Section 9 is self-assessment. After the self-assessment made, no order has been passed. What happened in Hussain Steel Mill, this Honorable Court passed an order which says that the coal is not a raw material for the finished product.
Right.
So that is subject matter of challenge in Supreme Court at present is pending.
Right.
Here also coal is used as a raw material.
Right.
That's the reason why in self-assessment, referring to Rule 4, Subrule 3, we have taken the benefit of discount of 5%, 0.5%.
Right.
No, that is now, he has opened it after the judgment has been passed, saying that since the judgment has been passed, now I'll do it on 10-3. 10-3,
Right.
kindly read the language.
Right.
Where any order passed by the assessing authority, the opening word is where any order passed by the assessing authority in respect of a dealer for any period is found to be erroneous or prejudicial. I'll pause a moment to say before I complete the reading that there is no order of assessment in this case, number one. Number two, to the interest of the revenue subject to or in the light of any judgment or order of any court or tribunal which has become final and binding, then notwithstanding anything contained in this act, the assessing authority may proceed to reassess the tax payable by the dealer in accordance with the judgment or order at any time within a period of 3 years from the date of judgment or order.
No, if you just see the wording of 9(2).
Yes, my lord. But then some order must be there which is found to be erroneous and prejudicial to the interest of the state. There is no order has been passed which is prejudicial to the interest of the state. But second part is, if you're also
No. Prejudicial to the interest meaning, see, if it is accepted, just see 9(2).
Yes.
If a registered dealer furnishes the return and the return so furnished is found to be in order, it shall be accepted.
Yes.
That acceptance is by what? By an intimation?
No, nothing has been done. No order has been passed. No intimation is there. I'll satisfy your lordship on that. Number one. Number two, the assessment has been read rightly or wrongly. If your lordship looks at the order that has been passed.
In fact, my lord, that issue is pending in that batch of matters. Referring to that VAT Act, my lord has kept these OET matters pending. Last batch of matters are there. Without self-assessment, there cannot be escape assessment. Those matters are pending, my lord.
Without a regular assessment, you mean?
Yes.
I see. When is that coming up?
In fact, after the Honorable Apex Court dismissed our SLP in that VAT matter, those matters have been mentioned, and my lord has said that my lord will take it up. No date has been fixed.
Yesterday also they had.
This SAO is mentioned.
How come the DRS will not explain? This also will place with that batch then.
Yes, my lord. But another independent point is also, legal point is there. If you also kindly look at the assessment, what he has done, he has assessed under section 10(3) and also levied penalty under 10(2). That is not permissible. If you also read the language of 10(1), 10(2), 10(3). 10(2) says, if there is an escape assessment of 10(1), not 10(3). 10(3) is separate because 10(3) is on the basis of a judgment passed by the subsequently by the either High Court or Supreme Court. So he cannot attract 10(2) under 10(3).
Right. But anyway, you have to get rid of the 10(3) order.
Yes. That's right.
So one of the issues raised in the present petition is whether the assessing officer could have exercised jurisdiction under section 10(3) of the OET Act 1999 when there is no assessment order as such. Since full stop, it is pointed out that in the first instance, there was a self-assessment by the dealer in terms of section 9(1) read with 9(2) of the OET Act 1999.
Yes.
And there was no order as such passed by the assessing officer in respect thereof. Paragraph, it is pointed out that this very issue, namely whether there can be a reassessment order without there being an assessment order in the first place, is pending before the larger bench of this court. Can you give me the writ petition number?
7458 of 2015.
In writ petition civil 7458 of 2015, list this petition with the said batch of petitions before the larger bench. Right. Interim order to continue.
Right.
Weekly list item number 56.
May please. Counter of 5 and 6 not filed till now.
Yes. My lord, I am appearing for IDCO. In WPC 7411 2013, I have filed a counter, and that may be tagged and that may be adopted in rest of the cases.
All right. That's not listed today.
No, my lord, that this matter has not come.
Not. It is from 1 to
list along with 7411
Yes,
of
ma'am.
2013. A huge batch
Yes, sir. 11 to 20.
on 18th October. All right.
18th October.
Weekly list item 57.
None appears this is number.
Weekly list item number 58.
The petitioners are the permanent residents of Rajgangpur municipality, my lord. In the residential area, one country liquor manufacturing unit is operating in the area. They have made a representation to the collector.
This is all 9 years old, sir. What is happening now?
My lord,
This is a 9-year-old matter.
my lord,
No interim order, nothing. By now, the another shop would have been opened there.
no, my, that is a manufacturing unit, my lord. It was closed for some time. Since last 1.5 years, it is.
Then you
again
file a fresh
operating.
representation. Counsel the petitioner seeks leave to withdraw this petition with liberty to file a fresh representation if any cause of action survives. Disposal is withdrawn with liberty. Yes.
Weekly list item number 59.
None appears dismissal not possible.
Weekly list item number 60.
59, my lord. Item number 59. My lord, the petitioners are land hostage and their lands were acquired for the purpose of construction of minor irrigation project, my lord.
When was it acquired, sir?
Acquired in the year 2006, my lord. So far as the compensation is concerned, they have already received. And so far as the benefits to be extended under the rehabilitation and resettlement policy promulgated in the year 2006 is concerned, they have not been extended, my lord. After having received the compensation under the Land Acquisition Act,
There's a grievance petition. Have you actually served this Annexure 7 on the other side?
Annexure
7.
7, my lord.
What is that to show you actually gave it to the other side?
Annexure.
It's undated.
Annexure 7, my lord.
What is the date?
Date has.
When was it handed over?
My lord.
What is proof of handing over this?
That has not been.
Then
mentioned, my lord.
no questions, sir. How can we pass any orders?
My lord, what has happened in this case, my lord? After having received the compensation, the opposite party number 4 prepared a list of the displaced and affected persons, wherein and whereunder the names of the petitioner don't find place, my lord.
Sir, unless you make a representation to them, how will they examine all this?
I will file fresh representation.
Counsel for the petitioner seeks leave to withdraw these petitions with liberty to file fresh representations. And after following up on such representations, to seek appropriate remedies in accordance with law. Disposed of is withdrawn with liberty is paid for.
Item 60.
67.
Same thing, sir. Both these petitions.
Weekly list item 61.
May I please? The management and the petitioner before my lords and challenging an order passed by the Land Industrial Tribunal declaring that the workman is entitled to the benefits of the order passed by the Honorable Supreme Court, wherein it is held that if the workman is continuing in the Hirakpur dam project prior to 1/4/1960.
So we serve the other side, sir.
My lord, I am for the OP number 1. And on behalf of to the impugned order at page 13, Annexure 3. Well, entirely on presumption, the Land Tribunal has allowed this application.
How old are you, sir? Your client.
Well, he has expired. His legal heirs are prosecuting the petition.
What is the relief granted?
Well, he has been declared that he is entitled to all the financial benefits of a central government employee.
My lord, we have sought instruction from the legal heirs. So this case may be adjourned and taken up in the next week.
No document was adduced. No documentary evidence. Yet the claim has been allowed. Your lordship may kindly turn to page 11, Annexure 2. That is our objection filed before the Land Tribunal. Our case before the Land Tribunal May I place my page 11?
Yes.
Objection on behalf of opposite party note 2 and 3. That the applicant was appointed as work worker and joined in the office of the SDO Canal Subdivision Borgad under the Executive Engineer Canal Division Borgad on 7/12/1964 under the, you let me kindly mark these dates, 7/12/1964 under state scale of pay. He retired from government service on superannuation on 8/6/1978 afternoon under opposite party number 3. That the opposite party number 3 has stated that the applicant was working there under for the period from 4/9/56 to 6/56, 10/59 to 3/60, then 8/75 to 5/76. You also can see from March 1960, he was not in employment. Then you also can see last paragraph of the same page, that the norms fixed by the Land Labor Code Sambalpur by the order dated 25/5/89 as follows to identify a workman entitled to get CPWD employee benefit. He must be in service as on 31/3/1960 as well as 1/4/1960. He must have been issued with a termination notice of a kind, the substance of which has been extracted in the award of ID case number 3 of 64 or of any other alike notice issued for specific reference with specific reference to the decision of the government of Orissa in their irrigation and power department letter number so and so. 3. In pursuance of such notice, he must have been adjusted against vacant post in the state government without there being any break.
So, no. One point that the labor code seems to pick up is that he got promotion as Sarkar in 64.
Yes.
He says the government pleader admitted that
you'll also can see after
he was appointed as Amin in 1955 and got promotion on 7/12/64.
Yes, you also can see well, he was in employment till March 1960. Thereafter, he was terminated. And the scheme which was framed by the land tribunal that I placed at page 12, well, he must be in service on 1/4/60, on 31/3/1960, as well as on 1/4/1960. So from 1/4/1960, the present workman was not in service.
No, just come to this. I don't know what page number this is. Internal page. There's no internal page also. There's no page number. How is this?
May I place you lots me can see the
the award. Come to the award.
This award running page 19, paragraph 7. You lots me can see.
No. Come to para 9.
No, it starts from presumption. Starts from page 7.
No, that's it. Sorry, page 7. The para 7. Correct.
Yes, para 7. Here the question arises whether the applicant Mutyunjay Panigre was comes under the norms of the order of Honorable Supreme Court. The advocate on behalf of the applicant submitted that the applicant was appointed as Amin in the year 1955 in the work charge establishment of the Hirakud Dam project in Canal Subdivision Borgad, which is now under Sambalpur Irrigation Division, Bulla, where it was under central scale of pay and conditions of service by the government of India. Admittedly, the applicant got promotion on 7/12/1964 as work worker by the order dated 2/12/64. The land government period submitted that the applicant was appointed as Amin in the year 1955 and got promotion.
So this is your own government pleader saying this.
You also can see our objection.
No, whatever your objection, this is what is submitted in the before the court.
No. Our objection, written objection is there.
But this is the submission made in court. You are supposed to ignore what is argued in court and only go by the written submission. That is very strange, sir. This is your government pleader telling the tribunal that this man got appointed in 55 and got promoted in 64.
You also may kindly come thereafter.
What should the labor code do? That's why the labor code is saying if it is apparent from the record that he is service on 7/12/64.
No, he was not in service.
Sir, this is just read the next line.
Yes, the land government pleader submitted that the applicant was appointed as Amin in the year 1955 and got promotion on 7/12/64. Unless the applicant was serving under opposite party number 213 since 1955, how he got promotion on 7/12/64? It is apparent from the record that the applicant was in service on 7/12/64 under the state government scale of pay as work worker. So from the above contents as well as documents.
So what is wrong with this? If you are
I am placing a lot. So from the above contents as well as documents filed by both the parties, it can be presumed. Now it is presumed that the applicant was in.
Naturally, if he's got promotion in 64, it should be presumed he was working in 60.
No, we have filed the documents. You also can see page 11, we have enclosed all the service document that he was not in service.
No. Just come to the bottom of that. But both the parties, just come down.
But both the parties have failed to show the documents relating to such period. There is no document filed by both the parties to show that the applicant must have been issued with a termination notice of a kind, the substance of which has been extracted in the award in ID case number 3 of 64, or of any other alike notice issued with the specific record.
So there is no termination notice, no order of termination, nothing. You don't place those documents.
No. I was not the claimant, my lord. Claimant has to prove
Termination, sir. You are now saying that after 31,360, he did not serve. That is your case.
Yes, till 64, he was not in service.
No. Now don't change. You just now said.
That is our written. I placed that paragraph.
Let us be clear, sir.
Yes.
You said he is not in service after 1960, 31/3/1960. That is what you have written in your written submission.
No, he joined on 7/12/1964. That we have stated. That date I placed reliance.
No. I thought you said he was terminated in 60.
No. Page 11, you can see. He was appointed as first paragraph. We have stated that he was appointed as a work worker on 7/12/1964.
But why did you go on telling the labor court that he was appointed as Amin in 1955? In more than one place, your submission is recorded that he was appointed as Amin in 1965.
And
he was promoted as Sarkar in 64.
And in the second paragraph, we have enclosed all those documents regarding his engagement. That he was engaged from April 1956 to June 56. Then thereafter, there was a break of 3 years from October 1959 to March 1960. Then from April 1960, there was no service. There was a break till December 1964. He was engaged as a work worker.
No. So he was engaged, sir. In the second paragraph, from April 56 to June, October 59 to March.
Yes. No, the scheme which was framed by the land tribunal, that is...
No, for this, there's no documentation. This is what I think the tribunal is pointing out. In fact, in 2 places, the tribunal says, you informed the tribunal that he was employed as Amin in 1955.
No, that is not our case.
Sir, but that is recorded in the award, sir. The government pleader said this.
No, that is his case. 55 is his case.
No. Government pleaders. Come to para 7 again. I think we have to again go through this with you. You yourself read that line and again you deny it. I don't know what to do, Mr. Mudli. I'll read it again with you. The government pleader has said this.
Yes. But this submission is contrary to...
So what is the labor court supposed to do?
Well, he has to go with the record.
Ignore the submission made in court. He has to go only by the written statement. This is very strange.
Statement. We have also enclosed the documents.
There's no document enclosed, sir. For the second paragraph, which you're showing that he was engaged between March and April 60 or whatever.
Yes.
No documents have been submitted.
We have, there is 2 documents. First paragraph, we have enclosed the original service roll. Then in second paragraph, we have also enclosed the copy of letter regarding engagement.
All those records are viewed and this is what the tribunal has said. We won't go behind this. This is all factual. So 227. We're not going to go to all.
He has to substantiate his claim.
All right. You're converting us into a second appellate court. Basically, that's what you're saying. Again, go threadbare into the documents.
Once the claimant approaches the court, he has to prove his...
All of you people are chasing somebody who died 2 decades ago. His family is here fighting.
No, there are not only this is a single case. There are 1,200 workmen. That is the whole debate.
Your litigating capacity is immense. These workmen have no litigating capacity. So their families are even less. This is the 3rd generation of this poor man who's fighting.
Probably this will not end here.
No, it will definitely not end. You know that. He also knows it. Anyway, we're dismissing it. We'll pass the detailed order. I'll pass it. All right.
We can list item number 62.
Item 62, 63 and 64 pertain to yesterday also there was the question of RNR policy with regard to Vedanta, and there were a number of project affected persons and their grouse was that they were not considered for employment. My lords, yesterday...
Your Lordship, similar matter is WPC number 111
6/8 of 2013. It was listed yesterday. Your Lordship were pleased to dismiss it.
Yesterday,
on the ground that-
item 52 of special weekly list.
Yes. So similar order. Only one distinction is there. Lordship had observed that in that case, the person who was claiming employment was a student, while it was in all these cases, no students are there. They said that R&R policy does not apply to them. The same analogy which was there, Your Lordship, is the same. Only that student has to go. That's actually one distinction.
No. What are they? They are not graduates at all.
No, these persons are not graduates at all. They're not PDF. The project displaced family to whom the R&R
They are
policy
PAPs.
applies.
They are PAPs.
PAPs.
All right. Do you have that order? Yesterday's order?
It's not yet uploaded.
Yet to be uploaded.
The order is not.
All right.
I can write a reference.
In light of the order passed on 18 July 2022 in WPC 1168 of 2013.
11166.
These petitions are disposed of. Dismissed, sorry. The order to be passed. Just saying a short order to be passed. Right.
All three members. Weekly list item 65.
65, my lord, permit to withdraw, Lordship.
Counsel, the petitioner seeks leave to withdraw this petition. Dismisses withdrawn.
Weekly list item 66.
My lord, 66, my lord, file has not traced out, Lordship.
So we'll not any. No, it's okay. Counsel, the petitioner says is unable to trace out the file. Dismissed with liberty to the petitioner to revive it if he locates the file.
Weekly list item 67.
None appears dismissed.
Weekly list item 68.
68, my lord, and the threshold, I would say only, there are three matters. My learned senior, sir, my learned senior is appearing in the first matter, which my matters have been tagged. In my case, no counter has been filed by the state as yet.
What are these matters about?
I am challenging a land acquisition proceeding initiated by notification under section 4.1.
It's all over, sir. The act itself is not there now.
Pardon?
That LA Act itself has been repealed now.
No, I am challenging non-making of resettlement pursuant to the notification under the rehabilitation policy. My confinement is to only non-settling me, not providing alternative of land, which have not been disputed by filing a counter to that.
So award must have been passed long ago.
No, there's this, first of all, there's a stay in the connected case.
In my
No. In your case, where is the stay in your case?
No, the same land acquisition proceeding. So
where is the stay in your case, sir?
Award has been passed. Award has been.
Then where's the question of questioning the land acquisition?
No, land acquisition proceeding, the award and the section 6 notification, we challenge on the ground of infringement of the provision of law.
There's no challenge to the award. Just come to the.
Yes, your Lordship may see that to Annexure 1 series is the notification under 4.1. That is 28.
Sir, after Indore Development Authority, these challenges don't survive.
No, challenge survives because if the award itself has been passed in contravention of 11A, section 11, because that.
You have not challenged the award. Just come to the prayer.
You haven't challenged it.
Entire proceeding have challenged. First the improved notification and the next one.
No, unless you challenge the award.
Further,
you have to challenge the award, sir.
Further,
you have to challenge the award. I'm sorry. You can't not challenge the award.
But I'll make an amendment.
No. Not at this stage. What are you saying? As it is, there's a new act.
No, what I'm saying.
Even if you challenge the award, that wouldn't survive. Because you would have got, either you have got compensation, you have received the compensation, or you have not.
No. Your Lordship may see, the award itself is time barred.
Sir, have you received compensation or not under the award?
90% of the people have not got it.
You're not answering the question, sir. Who are the petitioners? Let us go systematically.
No.
Have these petitioners received the compensation amount or not?
No, actually not all. but I
Anyway,
cannot-
you have lost possession.
Possession, no. I have, under the RTI Act, I have got the information. They have done nothing after they have done nothing after the acquisition. After the acquisition, they have done nothing.
So you have not challenged the award. I don't see how we can entertain a writ petition without a challenge to
Status
the award.
quo order is there, so.
There is no status quo order in your petition. Sir.
No,
Nothing.
in the same.
No.
Same land
In this
acquisition.
petition, there is no status quo order. There is no challenge to the award.
Lord, award I have challenged like this. Award is contrary to 11.
So there is no prayer questioning the award. Please read the prayer.
We have challenged the entire land acquisition proceeding.
That's not the thing, sir. If there is an award, it has a very different connotation altogether. The land vests in the state. Unless you challenge the award, we can't entertain a challenge to the section 4. It doesn't survive, in fact.
In fact, the interim prayer was that the award should not be passed, which has been.
Exactly.
Interim.
What is the date of the award?
That information, because we have just said that it is after the
the counter will
stipulated date.
No.
Counter the award date is not in the counter.
We have just stated that the award has been passed beyond the time stipulated under 11.
All this is vague, sir.
Beyond the time limit prescribed under 11A. Your Lordship may kindly see 11A for a moment.
So first, show me which is the date of the award. Then we'll talk about 11A.
Some of the awards we have annexed in our agenda. Your Lordship may see that. Some of the awards. And that is 13th August. 18th August 2013.
No, it must be much earlier, sir. The compensation amounts were paid in June 2013. Part payment.
Part payments have been made.
So award must be earlier. The payment is made only if the award.
But the question here remains, Your Lordship may see whether the award has been passed within the.
That is not your prayer, sir. I'm sorry, it's not your prayer.
But Your Lordship may then, may I pray, my Lord, one thing? Lord, I'll withdraw to refile a better petition.
Counsel the petitioner seeks leave to withdraw this petition with liberty to seek other appropriate remedies as may be available to the petitioner. In accordance with law, disposed of is withdrawn with liberty is paid for. Yes. What about the other matters, sir?
Yes, my other matter is, my lord, non-settling me under the 2006 rehabilitation policy. I have given a detailed.
No reply has been filed.
No reply has been filed.
All right. In both these matters, replies be filed within 8 weeks, rejoined up for the next date. What is the interim order?
My lord, interim order, Your Lordship has granted status quo.
What is status quo, sir?
Status quo, my position may not be disturbed because without resettling me, they're throwing out of position. Your Lordship has protected my position.
Rejoined to be filed for the next date. Interim orders to continue. 14 November.
My lord. Both the matters are same. Man.
Yes.
Weekly list item 69.
Item 69 may please. Item 69 no instruction have been.
No instruction.
Item 70.
Obliged news.
None appears dismissal not possible.
Item number 71.
None appears dismissal not.
I'm on behalf of the petitioner Workman. Petitioner Workman has challenged the award dated 11th March 2013, passed in ID case number 70 of 2002. That's paying therein for the reinstatement with full back wages. The petitioner has not challenged the entire award, but they have challenged the for the full back wages. Let kindly come to the page 17 of the award. In view of the discussion made above, the workman is.
How long did he work, sir?
My lord?
How long did he work for?
I have worked from the 92 till
2000.
99. I was
7 years.
Suspension.
And he's giving you 20,000.
My lord.
Who's for the management?
Sir.
The prayer is very limited, sir. He wants only enhancement of compensation.
Towards the compensation, he has already received the compensation of 20,000.
20,000 is nothing, sir. You increase it to 50,000. 7 years.
My lord, that is the awarded amount of the presiding officer.
I know. That's why he has come here, sir, because it's so meager.
My lord.
You say this limited ground on which the petitioner has challenged, the petitioner workman has challenged the impugned award dated 11/3/2013 passed for the Labour Code Bhubaneswar in ID case number 75/2002 is that.
But my lord, he did not join in spite of his transfer to Lanjigad.
That's okay.
He
That's
has
all
not
in
been
merit.
joining.
You have not come in appeal, sir. You say is that despite finding the termination of his services to be illegal and ordering his reinstatement, the Labour Court has given an inadequate compensation of just rupees 20,000. Paragraph, this court has heard learned counsel for the parties. Stop. It is seen that admittedly the workman was engaged from 1st April 1992 till 23rd August 1999, which is a period of 7 years. Stop. He was working as a clerk cum supervisor. Stop. In the circumstances, the compensation for illegal dismissal could not have been as low as rupees 20,000. Stop. In the considered view of the court, the interest of justice will be served if the management is directed to pay a further sum of rupees 30,000 to the petitioner as compensation. The amount will be paid within a period of 8 weeks from today. Petition is disposed of.
Weekly list item 72.
Nice.
In this case, the petitioner has challenged the expiry cycle style order under Annexure 3 passed by the Service under Service Settlement Act, Annexure 3/24. But in the meantime, pursuant to that order, final order already published in respect of the
This is infractuous. You say counsel the petitioner states that the petitioner has become infractuous and is disposed of as such.
My lord, 15B observation term so that
that observation is not required. If you want to take the court,
he will prefer revision under section 15B. And the original copy may be returned to file a revision under section 15B before the member board of revenue. As per Act, my lord.
All right, counsel the petitioner seeks leave to withdraw this present petition with liberty to file a revision petition before the Board of Revenue against the impugned order in accordance with law. The originals be returned subject to substitution with photocopies thereof. The
Original copy of Annexure 3 may be returned.
Yeah.
Weekly list item 73.
No, interim order because it is state. The status quo interim order till maybe.
When you file, you will ask for it there, sir.
Within 1 month, you will file the revision. Till then, the status quo of interim order 24.
All right. If the petitioner files the revision petition not later than 29th August 2022, the interim order passed by this court will continue till such time the Board of Revenue passes an appropriate interim order on the application of interim rate. All right.
Weekly list item 73.
This would be infractious, item 73.
None appears this was not possible.
Weekly list item 74.
My lords, in this case, an order was passed by this honorable court, which is at running page 8, that I am to deposit a sum of 23 lakhs and then they will return my documents within 2 months. I have deposited this 23 lakhs. That is at Annexure 2 at running page 9. Within 2 months, my lords, from the date of the order. But they have not returned my documents, my lords, and I have kept it with them, my lords.
Yes. Whom are you appearing for? The bank?
Yes, ma'am.
Huh.
You'll also kindly see the order dated 20th November 2012. May I read, ma'am?
Yes, yes.
In
please.
view of the above, considering the prayer made by the petitioner, it is directed that if the petitioner deposits the balance amount as per the settlement, and what is settlement is at page 10 of my counter.
No, it's there in the previous paragraph.
Yes. It appears from annexure to the miscase that the opposite party bank has entered into a settlement with the petitioner, agreed to postpone the action under Surface Act for the time being. If a sum of rupees 23 lakh is repaid by the petitioner on or before 31st July, it further appears that the said letter, it further appears from the said letter that a sum of rupees 50 lakh was paid by the petitioner pursuant to the earlier compromise.
So according to you, what is to be paid? Not 23 lakhs?
No, my lord.
What
I have annexed the letter, basing on which, in consideration for which the order has been passed. Page 10 of my so-called annexure C1. The old compromise of our date was 4/9/2009. Letter dated 28th July.
No. So how much is even this 38 minus 15 is 23 only? Even in terms of this annexure C1, page 10.
Yes, ma'am. We appreciate the discussion held by the chairman on the 26th July 2012 at head office in presence of the undersigned regarding repayment of the loan availed by you, wherein the chairman agreed to postpone the action under Surface Act for the time being if a sum of rupees 23 lakh is repaid by you in your loan account on or before 31st July. His contention is that
Read on, sir, don't stop.
This is to revive the old compromise amount, compromise of rupees 38 lakh on 4/9/2009, against which 15 lakh has already been received. He has, however, agreed to stagger repayment of the balance dues at simple interest at the rate UGB PLR rate for the delayed period with incidental cost and legal charges in suitable installments in next 6 months.
So what is the amount he's supposed to pay? You told him, you told the court he pays 23, you will agree. Where have you intimated him, which is the amount he has to pay other than 23?
Para 9 of my so-called, my lord. I mentioned 15 lakh, 48,090 rupees.
When did you intimate this to him, sir? Where have you written to him that this amount should be paid? How have you calculated it?
My lord, in the, page 10, my lord, of the contempt petition.
So that page 10 simply says 38, 15 and 23. Only 3 figures are here.
No, page 3 of the page 10 of the contempt petition.
Under petition. All right. Contempt petition doesn't have 10 pages.
Page 10. It is there, annexed.
Same letter. This is the same letter as your page 10.
Or same letter.
Asha, Asha.
It is dated 21 January 2013.
2013. After I made the payment, my lords, which is contrary to the letter dated 28/7/2012.
So that letter is a bit vague. If you actually read that letter carefully, the last line here is however agreed.
Yes.
That's the whole catch there. So it was not just 23 lakhs.
No, here's how, if your lordship reads the entire letter, they say we are reviving your compromise petition of 38 lakhs. 15 lakhs you have already paid. So 23 lakhs I have to pay further. He has, however, agreed to stagger repayment of the balance dues at simple interest for delayed period. So if there was a delayed period, this is on 28/7/2012. So let us say, my lords, on 28/7/2012, I had to pay totally 38 lakhs. 38 lakhs, I had already paid 15 lakhs. So I'm
No. The old compromise, I don't know the date, on 4/9/2009.
Yes,
so probably they're calculating that you should have paid 38 lakhs on 4/9/2009. If you don't pay the 38 lakhs by that date, whichever date you pay by, they'll calculate all the simple interest, everything. That's what it means.
They never informed us, my lords, even during this letter, my lords, your lordship.
No. Now that's how you filed the contempt petition, sir. They've informed you on this after you made the 23 lakhs.
Yes, my lords, on 2011/2012, they don't come up with such a. My lords, and ultimately, by Annexure 3, they intimate us this, that you have to pay another 15 lakhs. My lords, the entire. My lords, if your lordship sees that letter dated 28/7/2012, there they say you out of 38 lakhs, you have paid 15 lakhs.
But anyway, how is all this contempt? We fail to understand. What is the contempt petition about?
They don't give me the proper account.
No. That because you have to pay the balance amount.
No, true, my lords. Balance, if there is any balance.
So there's no contempt made out here, sir. If you want to challenge this letter, you take appropriate steps. There's no contempt here.
Your lordships may observe that.
All right. Having heard learned counsel to the parties, the court is of the view that if the petitioners agreed by the letter dated 21st that there is no disobedience of any order passed by this court on 22nd November. Order passed by this court on 20th November 2012 on the basis of the letter dated 28 July 2012 of the opposite party bank. If the petition is aggrieved by the subsequent letter dated 21st January 2013 of the bank, it will be open to the petitioner to seek appropriate remedies in accordance with law. The petition is disposed of. All right.
Deeply obliged.
Vehicle list item 75.
Hello, there is a passed over matter. I don't know 55.
You have to wait, sir.
So item 75, this matter issue involved in this case is fully answered by your lordship minutes in the case of Keshav Automobiles. And the SLP filed by the state minutes has been dismissed by the Honorable Apex Court.
Correct.
And minutes your lordship's judgment is upheld. Now the only difference is in that case minutes reassessment order was not challenged because 39, 40, 40 not complied. So therefore 43 your lordship held not permissible. Here is a notice of reassessment on the same background. No 39, 40, 42. Thereby initiating 43, which I have challenged for lordship minutes. And your lordship an interim order protected me. So in the meantime, my little prayer is this company has gone into liquidation. Now the liquidator has filed a substitution application for lordship minutes. And I have also annexed a copy of NCLT Hyderabad's order minutes, where the petitioner is appointed with this condonation also.
All right. The 6810 for the reason stated, the delay is condoned. And then 6809 for the reason stated, the substitution is allowed. The memo, the consolidated memo of parties as given in annexure. Where is that? There's no consolidated memo of parties.
Consolidated minutes?
The consolidated cost title be filed.
Yes, ma'am.
Within a week. All right. Who's for the other side? Mr. Party, then this has to be allowed.
Yes, my lord, I've seen.
All right. In view of the decision of this court in Keshav Automobiles,
I have also given apex court's order also.
Oh,
But the first name is mentioned Rakhi Steel, but the Rakhi Steel, but the subsequent one which I have highlighted is SLP arising out of my lord's this honorable court judgment. That is SLP civil number 9823 9824 of 22. This is without case of otherwise.
all right. In view of the judgment of this court dated 1st December 2021 in STREV 64 of 2016, bracket Mrs. Keshav Automobiles, State of Orissa, which has been affirmed by the Supreme Court by its order dated 13 July 2022 in SLP Civil 9912 of 2022. The show cause notice dated 15th January 2013, bracket Annex 3 is quashed, and all proceedings consequent thereto are hereby quashed.
Well, that is a notice of assessment, in fact.
As I said, notice dated 15, notice of assessment.
Yes, ma'am. Notice of reassessment.
Notice of reassessment in VAT,
By the Annex
307, dated 15 January 2013, bracket Annex 3.
Annex 3, yes.
Yeah.
Sorry.
Yes, and all proceedings consequent thereto hereby quashed. All right.
I only request my learned
This you keep a copy of.
assisting my learned senior to serve us the copies of all the substitution applications for our.
Yes, yes. I will.
All right. All right.
I will. Wiki list item number 76.
None appears dismissed from prosecution.
Wiki list item 77.
Item 77, liberty may be granted to file afresh if the cause of action survives.
Counsel to the petitioner seeks leave to withdraw this petition with liberty to file a fresh petition. The cause of action survives.
Item 78.
None appears dismissed from prosecution.
Wiki list item 79.
None appears dismissed from prosecution.
Wiki list item 80.
79. The PIL matter, my lord. The petition for protection of land of Polsar Science College, my lord. Some persons, illegal encroachers, are encroached the land of the college, my
So
lord.
you have not named the encroachers. You can't file petitions without naming encroachers, sir.
My lord, I mean,
Counsel to the petitioner seeks leave to withdraw this petition with liberty to first file a fresh representation, naming the encroachers if any cause of action survives, and thereafter to seek appropriate remedies in accordance with law. Dispose of is withdrawn with liberty.
Item number 80.
Lordship, no instruction.
No instruction, dismissed.
Item number 81.
No instructions, dismissed.
Item number 82.
Item 82, my lords. I am appearing on behalf of OP number 5, my lords.
All right. None appears to the petition.
My lord, item 82, the matter has become infructuous.
All right. Counsel to the petitioner states the petition has been rendered infructuous. It is dismissed as such.
Permitted to withdraw, my lord.
Number 7. Item number 83.
83, Lordship, is the public interest litigation. The opposite part number 6, 7, and 8, Lordship, can you see page 16? Opposite part number 6, who is a police officers, and 7 and 8, his mother and brother. The report says on the obtained under the Act, they have obtained encroachment made over 4 acres of jungle land and planted the.
Anyway, you only want the encroachment cases to conclude soon.
Yes.
That's the only prayer.
No. That is the opposite party. The 5 has already filed the counter. They have already stated that the scheduled land has already been evicted.
So what do you want, sir?
What Lordship, the eucalyptus protected when the enclosure was planted, that may be protected for the interest of public. That is. Trees, the enclosure planted.
No, please. It's all right. You see, with the encroachment cases already having concluded and the encroachers apparently evicted, nothing survives further in the present petition. It is disposed of. All right.
Item 84.
84, no instructions, my lord.
No instructions, it is disposed of.
85.
Lord, I may please your word. The item 85, my lord. This is I am in a virtual, my lord.
Yes, carry on, sir.
My lord. The item 85, my lord. This is public interest litigation, my lord. The petitioner's only prayer, my lord. There are 6 number of sanction posts in Tangi Community Health Center, my lord, in the district of Khurda, my lord.
Sir, all service matters, we don't entertain. The prayers are in the realm of service law for which no PIL is entertainable.
No, no, my lord.
The petitioner is to seek other appropriate remedies, the petition is disposed of. Sorry, sir, we can't entertain this.
Health, my lord, health care, my lord.
It's all right.
Not available.
86.
Item 86, the matter has become infructuous.
Counsel, the petitioner states the items become infructuous, disposed of as such.
Item number 87.
My lord, liberty will be given because prayer no more survives. If survives, then
Counsel for the petitioner seeks leave to withdraw the petition with liberty to file a fresh petition if any cause of action survives. Disposed of.
88.
94 also my one of the item 94 same.
Same order 94.
Weekly list item 89.
None appears dismissed for non-prosecution.
Weekly list item 90.
90, no instruction.
No instructions, dismissed.
Weekly list item 91.
None appears dismissed for non-prosecution.
Weekly list item 92.
None appears dismissed for non-prosecution.
Item number 93.
None appears dismissed for non-prosecution.
Weekly list item number 95.
Matter 95 in virtual mode. This is a PIL file for implementation of the Bonded Labor System Abolition Act and the Central Success Scheme for release of issuance of release certificate and issuance of 20,000 cash composite cash benefit for 35 numbers of bonded labor who were rescued in 2019 from Dhinkanal and Punjab.
Are they still here, sir? Where are they now? Because for 3 years now, nothing has happened to this petition.
No, my lord.
It's not even listed once.
No.
Not even listed once.
No. Today, in fact, I got the file to argue this.
You better examine it and tell us if these people are
My
still
lord,
alive.
no, my lord. These people have already, after they were rescued, they immediately left through that.
Then what is the point, sir, now? Counsel the petitioner states that on account of the subsequent developments, the petition has been rendered infructuous. It's disposed of as such.
in that case, I am appealing for Union of India Bank.
All right.
Weekly list passport matter item number 45.
My lord, item number 45, I contacted the advocate who has sent the brief to me, my lord. He is at Mount Abu, my lord, so he could not contact the client, my lord. So he is at Mount Abu. Your lordship grant some time. I can obtain my instruction. Otherwise, your lordship may pass any order, my lord, because it's a delayed, my lord. So that I have nothing to say. But only thing, my lord, for the date when it was filed, I mean, kept for filing objection, he has made me ex parte and order has been passed. That is the illegality, my lord. So otherwise, the lordship say. After 4 years of closure, my lord, see the workman files an application for wages from 2002 to 2005. After 4 years of closure, he could have filed in 2003 also. Anyway,
Yes.
I'm not there. Only thing on the date when it was fixed for filing so cause first date, my lords. The lordship may kindly see first date 17/3/2019 9, and I was at ex parte. And this is the thing, my lords. If your lordship,
Who's the workman here?
Yes, I am appealing. In the order, it has been reflected that after receipt of the acknowledgement, you were set ex parte. Notice was issued, acknowledgement came back. Thereafter, you were set ex parte.
That was not posted for hearing also.
All right. The petition is dismissed. We'll pass the detailed orders. I'll pass.
Right.
Supplementary list. Supplementary list for a stress admission item number 1.
May I please, madam? Here, my lord, lordship may kindly peruse annexure annexure 2, my lord. The letter dated 19/3/2018 that will be available to my lordship at page 33, my lord.
You filed representations. What is that to show these representations were handed over?
My lord.
Your Annexure 5 series, you have postal receipts.
My lord, what happened, my lord? This honorable court has asked for a patch of land for establishment of...
Sir, are you following the question asked to you?
My lord.
Annexure 5 series.
My lord.
These are your representations.
Yes.
What is there to show that you were handed over to the authorities? Is there any postal proof?
Directly, they have given it, my lord, to the collector.
Where's the question of directly giving without getting an acknowledgement, sir? Nobody gives this kind of representation without getting an acknowledgement. Where is the acknowledgement?
There is no acknowledgement.
So this is very basic. If you give a representation to an authority,
Yes,
you
yes,
have to get an acknowledgement.
Yes.
You say permitting the petitioner to make a fresh representation to the authorities, and after following up with such representation, to seek appropriate remedies in accordance with law, the petition is disposed.
Supplementary list item number 2. May I please, Your Lord? A matter related to Sisubon. The order dated 17/11/2021. Lordship constituted a committee and visited directly.
You are going to file photographs and affidavit. What happened?
It is also there. Now I am file a press report. Some work has been done in the meantime.
Last occasion I had filed all these photographs and the development works. The lordships were pleased to direct them to visit once again.
Correct.
Now they visited, they will submit a report to lordships.
Some development has been done, but some development is still in progress.
We'll look into it now. We'll
And
go
that
through the
apart, my
report.
lord, some important things I draw lordship's attention.
An updated report dated 19 July 2022. A copy which has been handed over to Mr. Samantarai, learned counsel appearing for the opposite parties. Full stop. He states he'll examine the report and take all the corrective action as pointed out there, and submit a compliance report on the next date. By the next date. We'll have it next month or early in September. We'll have it on 5th September.
My lord, I have got small submission to made in this case, my lord. I am appearing for Maitri Sansad. In this case, Maitri Sansad is one of the petitioner in this case, my lord. They will, your lordship direction, they will carry out and will also obey. But there must be some alternative arrangement. Accommodation and the security arrangement in the premises is very much essential. For that reason, the government of Orissa has already making an alternative arrangement in Acharya Harihara, my lord. Acharya Harihara, they have already constructed 3 or 4 sets inside the campus, and other arrangement has already been made for the accommodation of the patient and their attendant. Accordingly, a letter has been issued by the administrative officer to the RDC. I am going to place the similar arrangement must be made, only because in the rainy season, the patients are suffering a lot, my lord. In the open sky, they are in the premises.
Now he says that the AO has already requested the RDC. We'll take steps, my lord.
No, already in Acharya, they have already.
That I know. That I know.
That you should implement that.
Mr. Ajay Monti,
take time, not that overnight it can be done.
No, my lord.
Mr. Ajay Monti hands over a letter,
my lord,
indicating that in the Acharya Harihar Postgraduate Institute of Cancer,
my lord,
instructions have been issued for constructing sheds,
my lord,
to accommodate patients and attendants,
my lord,
visiting the hospital premises. He states that a similar arrangement could be made in the Sishu Bhavan as well.
my lord.
Mr. Samantarai states that he will seek instructions on this aspect.
I will.
Some more points is also there for the purpose of Sisubon. MRI CT scan is not there. 100 patients are good outside from 10 kilometers from here.
You have not put it in your report.
Yes, madam.
That's
the last occasion we also put it, but to that effect they have not given any reply.
This time we've asked to file a complaints.
Madam.
Let's see.
On behalf of the committee, may I pray one more thing, madam?
Yes.
Your lordship directed to make all the arrangement by the Superintendent Sisubon, but no arrangement has been made. Some expensive bill have submitted before the registry. Only as per the actual, because no arrangement made by the. I also requested Mr. Samantarai that they have not made any arrangement. All video clips, pen drives, photographers are on behalf of the committee, my lord. They are placed. Highly small.
Because he says that the expenses incurred by them lords for taking photographs and videographs want to be involved. Let them lords submit a bill, lords. I will see that.
Already submitted, my lord, before the registry, my lord.
Before the registration, lords. How can I
give it to him, sir?
My lord.
Just give it to him. He'll do it.
My lord, oblige. Supplementary item.
Yes, may I make a prayer before lordships? Yesterday I argued on matter. Lordships are reserved for orders, lords. I made a small note. May I hand it over?
Yes.
So good.
Oblige. Supplementary list item number 3.
I am from the appellant. Next, this honorable direct to.
Sorry, in this case, I am for the respondent, my lord. Earlier occasion, your lordship directed to file medical certificate of the present respondent, my lord, and a payment of 78,000, my lord. The present petitioner was a bad respondent is a bad read my lord. Now today he sent me in my account 20,000 my lord. May I permit your lordship? I do.
What is this in bits
Here
and
my
pieces?
area maintenance is 78 maintenance matter my lord. Present
No, what is this in bits and pieces, sir? Your balance amount was what?
78,000 my lord. Now he's a bad reader my lord. That's why your lordship directed to me to file a medical certificate. Man.
Where is
He unable to move bad reading my lord. Unable to move my
Where is that medical certificate?
Yeah, my lord. I'm just he sent me by mail my lord. That's why I'm filing just now. In my account, he also sent me 20,000 my lord. I'm ready to pay my lord, my learned friend my lord.
How are you paying him?
20,000 my lord.
How are you paying him? Have you paid him?
Not only he now bad reading my lord.
Where is the 20,000, sir?
In my I served him.
Huh?
Just now in my account he sent today my lord just now.
Where is it, sir?
I'll give him my by cash. I'll.
When will you give?
Within a half an hour I undertake that. He already sent to me my lord.
This is some 16th June, sir. We are in
Some document now he sent me by mail my lord. Today I
just have to call him here, sir. There's no option.
I think he's
taking the court for a ride.
He now
He's taking the court for a ride.
Some money my lord.
I think we'll ask we'll issue a bailable warrant, I think.
Now bad reading my lord. That's the problem.
It's all right. They will know how to get him here. They can even put him on a stretcher and get him there. If this is the attitude, he's so casual about the whole thing. And then he sends you 20,000 when he has to pay.
Another 15 days, your lordship. I read it. He arranged the money, my lord. From relatives, my lord. Lordship, another 15 days.
Sir, you are going on like this. Even last time you kept on saying this.
Now he
I think it is not having any impact. It is not having any impact on him.
No income.
Because this is what you are doing. You're telling him, sir, I will manage, I will get an adjournment from the court. This is what you're telling him. Every day you're telling him this, he's feeling happy.
Nothing.
He has got a wonderful advocate who will do all the pleading here to get somehow dates.
No, and I undertake to solve him. I will read.
We'll just issue a bailable warrant be issued.
15 days we will
through the rest of what is the address? Barampur.
Yes, Barampur.
Through the concerned, which is the police station, Barampur?
Barampur, my lord.
Tell us. The medical certificates produced before the court do not indicate that as of date, the petitioner is not the respondent is not in a position to attend court. The court will stop a serious views taken of the repeated attempt by the respondent neither to appear before the court nor comply with its orders. A bailable warrant is directed to be issued to the respondent to be through the IIC of the concerned police station. That is police station?
Gosani Nuaga.
Bada Bazar. District Ganjam.
Ganjam, Barampur.
To ensure the presence of the respondent in this court. What is next Wednesday? 27. Counsel, the respondent says that the respondent sent 20,000 to him, which he will hand over to the counsel for the appellant today itself before 5 p.m.
Yes.
Full stop. It is made clear that the respondent should remain present on the next date with the balance amount payable in terms of the earlier orders of this court.
That is IIC Gosani Nuaga.
Sorry, my lordship, Boda Bazar district.
Boda Bazar. Then it's okay.
The Registrar General will ensure, or the Registrar will ensure that this order is transmitted to the concerned IIC or PS so and so today itself for compliance.
Supplementary list, item number 4.
Memo is taken on record. The petitioner is dismissed as withdrawn.
Supplementary list item number 5.
My lord, huge amount of government land has been transferred to a private parties. Then the villagers made allegations to the revenue authorities. The revenue authorities did not take any steps. So the petitioner filed a writ petition 30206-806-21 on 7.
So what we called out is item 5.
7 February 22.
What we have called out is item 5.
Yes, item 5 is a CMAPL. The petition was dismissed for non-prosecution.
He's arguing that.
Yes.
Your matter is Bharat Chandra Parida.
Sir.
You have to say why you did not appear on the previous date.
On the date, due to virtual mode link was failure.
What's the main matter about?
The huge amount of land has been transferred by the government, Tahsildar Banki, in a private, which amounts 14 acres, 69 decimals.
So what is that to show this representation was given to the collector? We have proof of giving this representation to the collector.
Yes, my lord.
Where?
Page 17.
All right. For the reason stated, the application is allowed. The order dated 7th February is recalled. The petition is restored to file. The main writ petition, you say the petitioner's representation, bracket annexure 1A, annexure 2, sorry, will be examined by the collector, right? Collector. Cuttack. And after issuing notice to the petitioners as well as opposite parties 6 to 9, and after giving them a hearing, a detailed order, reasoned order shall be passed not later than 10th November 2022. And the order shall be made available to the parties within a week thereafter. The court clarifies that it is not expressed any view on the matter.
Supplementary list item number 6.
One week time may be granted to remove the defect, madam.
All right. Defects be removed within a week. List thereafter.
Supplementary item 7.
May I please alert? My lord, this is the PIL and the matter related to construction of shelter home for the patients, attendance, IPD, indoor patient attendance in SCB Hospital, Medical College and other premier institutes in the state, my lord. And the petitioner made a representation by annexure 3, page 15, by annexure 2, page 13 to the chief secretary.
All right. The petitioner's representation to the chief secretary will be examined and he will be informed of the decision taken thereon by the Director Health Services not later than 1st October 2022.
My lord.
The petition is disposed of.
Supplementary list item number 8.
My lord, I may be permitted to remove the defect, man.
All right. Defects be removed within a week.
Let it come next week on any day, my lord.
All right.
Supplementary list item number 9.
My lord, item number 9, this is also a PIL and the matter related to misappropriation of PDS quotas.
That you go to the Lokayuk, permitting the petitioner to move the Lokayuk for the issues raised in the present petition. The petition is disposed of. All right.
Supplementary list item number 10.
May I please, your lordships? My lord may kindly look at order dated 15/3/2022 as the
So you paid the costs, OSFC has paid costs?
Yes, my lord.
Yes, my lord.
They filed the reply, though not served on time. That is what
I paid I complied the order dated 15/3/2022, my lord, by 20,000 to the petitioner, 20,000 to the opposite part number 5, and 10,000 to the Orissa State Legal Services Authority, my lord.
Right.
I have prepared a date chart, my lord. Your lordship may kindly go through the date chart. May I ask?
Yes.
Yeah.
So we'll just take it at the end of the board. One.
My lord.
We'll just pass it to, we'll take it at the end of the board. We still have other matters to go. Yeah.
Supplementary list item number 11.
or on some other day, my lord should take it.
We'll just see what it is, sir.
Item 11, today. Item 11, my order has been complied. Today I am filing the affidavit. Item 11. The order has been complied. Today I am filing the affidavit.
Who's for the petitioner?
I am for the petitioner. The order has been
All right. Counsel, the petitioner confirms that the order has been complied with. The affidavit, compliance affidavit is taken on record. The petition is disposed of. All right.
Supplementary item 12.
Item 12, filed by the state, it will take some time.
Who's for the other side?
My lord, I am for the opposition.
It's a 2010 matter, sir.
Yes, well, in fact, the impugned order is at Annexure 1, running page 9. Well, the workman was engaged as a daily wager in a building center which was closed down pursuant to a policy decision of the government. Well, consequent upon closure of the building center, well, he was discharged from the service. Now, he approached the Land Industrial Tribunal. We raised the protection under 200BB, we claimed exception, and that has been negative.
Exception being what? You are not an industry.
No. Since this building center under which the petition, the workman was engaged, since that was closed down pursuant to a decision of the government, well, so accordingly he has to discharge because the establishment is not there. That has been negative.
What about 17B complied with?
Yes, that is being complied pursuant to orders passed by this honorable court.
17B, sir. Have they complied with 17B?
My lord, after the order of the award, my lord, they have reinstated, and now I am continuing, my lord.
Then?
I am continuing. I am getting remuneration.
Why should you leave the question open, sir? He's continuing. He's been reinstated and he's continuing.
No.
I am getting remuneration
because every moment is stayed, my lord.
No. He says he's been reinstated. Clearly, the stay order has not worked.
Yes, your lordship, kind of order dated 23/8/2010.
Yeah, but he's been working, he says.
No,
I have specifically added in my affidavit, my lord.
Let's see that. Opposite party number 1, counter affidavit.
My lord, paragraph 12 of my counter affidavit.
He's good. He's getting 17B only. That is my instruction.
No.
That is my. Yes, that I have, on 21/6/2021, I have received the information from the Principal Government Polytechnic that Sadashiva Pradhan, he has received the 17B for the month of March, April, and May 2021.
What are you saying, sir? He says you got your 17B.
Well, the instruction.
No, 17B wages, probably he is saying that I have been regularly engaged. So the impugned award is stayed.
I think what you say in para 12 is he's getting remuneration / wages. That must be the 17B.
Yes, that's his.
Not that you're working there, sir.
No. You lordship, can turn to page 13.
No. This women's polytechnic is no longer functioning.
Yes, it's functioning, my lord. She was engaged in another place.
Where
he was engaged.
My lord, I have been.
She was engaged in a building center.
What difference, sir? Instead of paying, as if there are vacant posts, why don't you take?
No.
What's the point in paying 17B, not taking work? You're wasting the government's money. There's vacancy, you should take the person. And what is this post? What was he working as?
Watchman.
Watchman. So you can take him as any other peon, or
Because
so many posts must be there.
Because this annexure 4, that is the decision of the government on closing down the building center.
But by an interim order, you're paying him 17B for the last 12 years.
17B has been.
It's like no work, but full pay. Might as well take him. If you have vacancy, you should take him.
You see, there is no vacant post. That is why the management has challenged.
No, he has said in his reply that there are vacant posts.
Then I have to file the reply to them.
In the counter affidavit filed by the workman, it is inter alia stated that there are vacant posts in the petition number 2 establishment, in which he can easily be accommodated. It is seen that he is continuing to be paid Section 17 capital B wages pursuant to the interim order passed by this court for over 10 years now. Mr. Mudali states that he'll seek instructions on whether the petitioner can be accommodated in any of the vacant posts of class 4.
If there is any vacancy or not.
Yeah, if available in any of the vacant class 4 posts, if available. All right. That is request list on 20th September. Interim order to continue.
Supplementary list item 13.
13, I have the copy. I have also collected the evidence. The copy. You'll also may give me some time. I've collected the copy of the evidences from my friend. You'll also may give me some time.
In fact, this will require a little bit of a prolonged hearing.
All right.
So your lodges might fix up a date.
Or at the request of counsel of the parties. List on 12th October.
Supplementary list item 14.
Lord, can it be before the puja or maybe 1 week after that, whatever subject to your lordships, after 17th or maybe before the puja?
Yeah, 19th.
9th. Problem.
Supplementary item 14.
Item number.
Can't hear you.
Mr. Rath's name may be kindly deleted as the brief has been transferred. Item number 13.
13, okay. The name of Mr. Rath to be deleted. All right.
Item number 14.
Item 14, my lord. I have a prayer, my lord. I have the instruction to appear for the opposite party number 6, my lord. Barampur Municipal Corporation. So may I pay your lordship may call it on Monday, my lord. I will file my counter affidavit by Friday, my lord.
Counsel for the BMC.
Counter affidavit of municipality is required.
Required, my lord.
2 weeks time to file a reply with copies to counsel for the other parties. Response thereto if any be filed for the next date. 27th October.
Opposite party number 5, my lord. I am sorry.
26th October.
26
now.
August. Supplementary list item 15.
May I pray about interim order to continue?
Interim order.
I am appearing for Bhubaneswar Municipal Corporation, opposite party number 6. Petitioner has filed a affidavit which I received today. I want some instruction, time to file instruction. They have submitted that they have paid 41 lakhs to the Bhubaneswar Municipal Corporation for NOC. I want some instruction, my lord.
Where is the petitioner has filed an affidavit?
Yes, petitioner filed affidavit today and served me a copy.
Where is that? We don't have a copy.
Item 15, my lords, with leave of your lordship, we have submitted an affidavit.
Where is it?
That is with your lordship's brief at page 52.
When did you file the affidavit, sir?
It has been filed before your lordship's board on yesterday only.
Where is the copy? We don't have a copy. The affidavit said to have been filed by the petitioner yesterday is not on record. Counsel for the BMC seeks time to respond to the affidavit. Just on 9th November.
Supplementary item 16.
If I beg one line submission before lordship, subject to your lordship's approval. Here, Bhubaneswar Development Authority is a party, but they have been served with a copy, but nobody appears. May I be permitted to give a copy to Sri Mahapatra or anybody who normally appears for BDA?
That's up to you, sir. That's up to you. All right.
Item 16.
Much obliged.
May I please, Mr. Rashid, I have a very limited prayer in this application. I being a complainant, I filed a tax evasion petition. I just want the opposite parties to communicate me the broad outcome of that petition. That's it. And as a lawsuit, law is no more less of degree that I'm entitled to the broad outcome of the petition.
No, this tax evasion petition has been filed against whom?
Against my father-in-law and brother-in-law.
Ah, that's the whole point.
Just in the similar circumstances, the lawsuit has entered in and directed that the complainant is entitled to only broad outcome of the petitioner. I don't want any personal information. I just want broad outcome of that petition filed by me. I have filed certain judgments in which the similarly circumstanced person has been granted that. So, you may kindly take my rejoinder for a second. Mr. May I refer? Can I bring the lordship notice to page 36 of my rejoinder, Your Lordship? Page 36 of my rejoinder. Am I audible, Your Lordship? When through certain judgments of other high courts and as well as the Central Information Council, wherein it has been settled that the complainant is entitled to the broad outcome of the tax evasion petition filed by him. I just want that.
We'll hear it on some other day. You just say list for hearing on 22nd November.
Supplementary list item 17.
Mr. May I pray for a shorter date?
No, it's not possible, madam. Yes.
Item 17.
May I please, Lordship, here the opposite party. Today I am filing a further affidavit. I am also serving a copy of this.
Traffic congestion.
Lordship.
Widening of the highway.
Lordship. Acquisition of private land more than 200 houses are required. The draft proposal has been submitted to the government for approval and the approval is awaited.
This is enough, sir. You've got a copy of this.
Lordship, target the matter to conclude the same within stipulated time. Whether the here, Lordship, the opposite party is ready to.
On behalf of opposite parties 5 and 6, in which inter alia, it is stated that
Paragraph 8 is relevant to this.
Yeah. As part of the widening of and four laning, a detailed valuation has been made by the R&B division for acquisition of private land on direct purchase basis and payment of compensation for demolition of buildings. Somebody state that a detailed project report has been prepared and submitted to the R&B division on 4th April 2022. And it has been forwarded for administrative approval of the competent authority. There is no indication as to the time period within which the steps will be completed in this regard. A further affidavit setting out the timetable within which the work will be completed, filed before the next date. List on 28th September.
Supplementary list item 18.
Item 18, I am for the petition, my lord. I have received the counter. Let's me grant 2 weeks time to file in the regional draft, my lord.
Or it rejoined to be filed with the next date, 14 November.
I may be pardoned, which your lordships leave. Item 15, your lordship did please to fix it to 9th of November. May I only beg the interim protection?
All right.
I'm grateful.
Supplementary list item 19.
Item 19, Item 19, though I have filed the counter affidavit of the opposite party number 4, but today I am filing the counter affidavit of opposite party number 3.
All right. Reply of opposite party number 3 is taken on record.
I'll serve the
copy of the same be served on counsel of the petitioner during the course of the day. Rejoinder thereto, if any, be filed for the next date. 23rd November.
Supplementary item 20.
Your lordship has
My lord, item
Lord,
20.
sorry, my lord, your lordship is fixing it to
23rd November.
23rd November.
My lord, in item 20, my lord, your lordship is directed by the order dated 28/3/2022 to file the counter affidavit that the opposite parties have not filed the counter affidavit till date.
I am appearing for opposite partner of 5.
Your lordship has specifically directed to file the affidavit, my lord, the counter affidavit.
It's 20 minutes.
All right.
They have
Reply
not
is filed within
filed
4 weeks. Rejoinder for the next date. 29th November.
Supplementary list item 21.
Lordship, item 21, my lord, senior counsel, Mr. Pulka will have.
21, I pray for some more time.
My lord, can you see the last order, my lord? The last opportunity was given to the state to file the counter affidavit.
What happened?
But some more time because the draft counter has been prepared, but some more additional points were to be dealt with. That's why it could not be filed. That's some more time. In the meantime, I'll file.
A final opportunity is granted to the state to file its reply on or before 19 September 2022.
Please, grateful.
List on 28 September. All right.
Supplementary list item 22.
My lord, item 22, I have received an affidavit about the acquisition of the land and for the benefit granted. But the question which I have posed before your lordship, that has not been answered. My first question was whether the state, being secular, can acquire the land of an educational institution for purpose of a particular religion. That is one. Two, my lord, whether since the college in question is heritage in nature, it is the duty of the state to preserve and protect it as per Article 49 of the Constitution of India. That has not been answered. And in the meantime, I have also collected some other material, which I will also file in the shape of an affidavit to substantiate my pleading.
All right, counsel.
My lord, lordship may kindly hear me for a moment. The affidavit which I have filed, that is in terms of the last order of this honorable court, which I want to bring to your lordship's kind attention. Order dated 2/6/2022. Specific 2 questions were raised, and I was supposed to answer these questions by way of an affidavit. That is, last but 1 para. A detailed affidavit shall be filed by the opposite party number 4, Collector Cuttack, as to whether, in order to materialize Chandimandra beautification project, any land of the college is likely to be utilized, and if so, what provision has been made for giving suitable land facility to the college in lieu of such land likely to be utilized for the project, keeping in view the
You're saying
interest.
there's no land of the college which is being utilized?
No, your lordship may kindly have a glance, because the affidavit is very specific and pinpoint. I have answered the query raised by the honorable.
Where is that affidavit?
Yes, it is there. By internet, mail filing, I have by email. E-file. Filed on 13/7/2022 through email mode. I'm giving the first copy and second copy, hard copy also. Lords may kindly have a glance at paragraph. Para 3 of my affidavit. I have given the hard copy. I'm sorry, para 4.
Yes.
That as regards the query number 1, as indicated in para 1 supra, this opposite party begs to submit as follows. Admittedly, the playground of the Salawala Women's College is partly covered by plot number 45 under Rakhit Khata number 674, and as such, it is a government land. A copy of the ROR is annexed to A/4. The total area of the said government plot number 45 is 3 acre 450 decimal, and the R&B division Cuttack prepared a plan for the integrated
So it is a
development.
government land.
It is a government land.
My lord,
And just a minute, madam. And approved plan, and a copy of which is annexed here to us. According to the said approved plan for the aforesaid project, a part of government plot number 45 is required for shifting of the public road in front of Katak Chandi temple so that the temple complex can remain within a defined boundary wall and a parking space can be created for the devotees visiting the temple. At present, there is no parking place for the temple and a lot of traffic congestion is created near the Chandi temple, especially during the occasion of different festivals. A sketch map is prepared and filed on 30/6/2022, showing in green color the portion of government plot number 45, measuring an area 0.0557 decimal only out of the total area 3 acre 450 decimal of the said plot required for shifting of the public road. A copy of the said sketch map
Only
is
the
annexed.
public road is going to be shifted.
This front road is only, your lordship may kindly have a glance over exhibit C/4 annexure. I have given the map, green colored, a small portion, and I have also explained. Thus, a small portion of the government plot number 45 is going to be utilized for the purpose of the road, leaving aside a major portion of the said plot, which is being utilized for playground purpose, along with the adjoining plot number 47, with area 1 acre 871 decimal. So the net effect is that though a minor portion of government plot number 45 is being utilized for the project work, yet the size of the existing playground of the college has been increased. So, lordship may kindly imagine, we have increased, we have amalgamated the
Adjoining vacant space.
Yes, and that is another government plot number 47.
No, my
and is going to be increased from 3,900 square meter to 4,800 square meter by including the adjoining vacant space. A copy of the report is annexed to. Next, your lordship may kindly have a glance at page para 5. That as regards the query number 2 as indicated in para 1, the opposite party begs to submit. The state government has in the meantime approved R&R policy for the project, hide letter number so and so. In the said policy at para 6, it has been noted that the compensation will be decided by the project implementation committee in consultation with the invitee members from SB Women's College and the Higher Education Department. In the said policy, the interest of all the land losers, including stakeholders, have been duly taken care of. Thereafter, the PIC was constituted, in which the chairman CDA Cuttack was nominated as the chairman, along with other official members, including the invitee members of SB Women's College and the Higher. The said PIC conducted a meeting on such and such day under the chairmanship of so-and-so Cuttack, specifically regarding utilization of acre 0.557 decimal of land of SB Women's College Cuttack for this project. The minutes of the meeting, this so-and-so is annexed so-and-so, which speaks for itself. The minutes of the meeting would indicate that several proposals have been made by the state government for renovation of SB Women's College Cuttack. And in fact, such developmental work of the college, it was decided that in 2 phases, sizable amount of fund will be utilized as clearly mentioned in the said minutes. Thus, as per clause 6 of the R&R policy, annexed by 4, the PIC has taken decision to give suitable facilities, including additional land to the college against the proposed land, which is going to be utilized for the. And another one paragraph only. That to be more specific, it is apt to mention here that as per the decision in annexure F/4, in the first phase, a sum of rupees 6 crores odd shall be utilized for the developmental work of the college, as mentioned in the said minutes of meeting. And in the second phase, a sum of rupees 79 lakhs some odd shall be utilized for all other developmental works of the college. What are the developmental works? That has been indicated in the minutes. It is more particularly mentioned in the said minutes of the meeting that a piece of land measuring 5 acres, your lords may kindly imagine that a piece of land measuring 5 acres will be given to the college out of the reclaimed land for playground at Hadiapatha near Matamata Square, which is within the CMC area and within 2 to 3 kilometer distance from the college premises. It is further decided in Annex F by 4 that depending on availability of fund, there will be subsequent developmental works in the college. That as narrated above, it is humbly respectfully submitted that in lieu of acre 0557 decimal of government land from the college premises, which is being utilized for the purpose of road, without affecting the very structure of the existing playground, suitable land facilities are given to the college, and therefore neither the college nor the students' interest at large is going to be adversely affected. So your lordship may kindly imagine that whatever facilities we have provided to the college in lieu of only 557 decimal of land from the, our government land, it is recorded in government khata, and the very structure of the playground is unaffected. If you are interested to save the playground, we are also more interested than you. You are the old student association, we are the government. We are also more interested to see that if the playground is better, in a better position, and it should maintain its own characteristics. And we have developed it. And if your lordship will see the R&R package for development of the playground itself, we have we are going to spend a sizable fund, and it is matter is already passed. The government has already approved the project. So at this stage, filing this PIL that it is going against the students, it is not, the students are not at all affected. There is another playground we are going to give at some other. Yes,
you have completed.
No, I have not completed, but you can say.
My lord, your lordship may kindly turn to page 23.
Yes.
Page 23, 5 acres of land has been given out to reclaim land for playground at Hadiapatha near Matamoto Square. That land is under NGT. That is one.
NGT means?
National Green Tribunal. That dispute is pending. That is one. Second, my lord.
No dispute is pending.
Yes,
no dispute is pending.
My lord, I will clarify.
For other purpose, we cannot use
my lord,
it.
your
Playground,
what NGT will do if it is used for playground? You have to imagine how
that
matter is getting confused.
My lord, no, my lord. I am not confusing. I am interested for the benefit of the college. For which I am. One more thing, my lord.
No, 1 minute. Madam, just come to that page 25.
Yes.
This playground, which is originally 3,900 square meter, is going to increase to 4,800
my
square
lord,
meter.
This
has nothing to do with the 5 acre.
No, that is, my lord, that is the crux. Your lordship may keep it to next week. I am clarifying the issue.
What?
But this portion, whatever they have stated, if they are taking away and giving us, there will be no problem. But that is not the fact. And another fact, my lord.
No. Tell us why it's not the fact.
No, it is
we
not.
have already served the copy to my learned sister since last 1 week, more than a week.
No, my lord, on 13th, I have 13th night, I have been served within.
It is today is
22nd.
Yes, I don't say no, my lord, because I need a breathing space. Your lordship may keep it to next week or day after tomorrow.
What is your response to
my
this?
lord, response to that, my submission before your lordship is that if they are taking away, that is not government land, whatever has been submitted, because that is in the name of the college.
Your ROR, it is totally wrong. Your lordship may kindly have at Annexure 1. A by 4.
Yes.
The ROR is at page 8. It is Rockit land.
No, maybe Rockit. Kisam is Rockit, that is bound to be. And the name is Soilobala Women's College.
No, name maybe. The question is, it's not the college land.
My lord, that is the college.
And anyway, you're getting more land.
I am not getting, my lord.
Page 9.
My lord, one more thing. My lord, it is 2 hostels are operating inside the premises. One is SCST, another is a common hostel. The sports has been played inside the premises for the last so many years. And
the adjoining land is being added to this playground.
Not the adjoining land. That is the problem. Your lordship may keep it to day after tomorrow.
You are not telling us what it is. You are going on saying it's a problem. Please tell us what it is.
My lord, one portion they have constructed for development of Chandi Mandir. They have constructed a toron, but a huge structure to show that it is Chandi Mandir.
That is last 10 years.
No, my lord, that portion they want to remove it and give it to us. And that is a small portion. That's what I
We are
have
not
got.
going to demolish any Toron. Your Lordship may record the
Toron,
statement.
My Lord, Your
It
Lordship.
is a
My
quarters.
Lord, may I pray if Your Lordship will keep it to day after tomorrow, neither they are going to be affected nor.
Why should we? We have spent so much time on this.
There is
Then Your Lordship, it is, my Lord, I cannot stand on the way. But two more things.
Yes.
When I have made two queries,
Yes.
whether that has been answered, if not,
That has no relevance.
that has a relevance.
No, please. This is an expansion of the road. One corner of that playground is being used for the expansion of the road.
Joining the road.
No, my Lord, that
There's
is
nothing to do with the temple on that portion at all.
my Lord, what is the
Only the road is going to be expanded in that area.
My Lord, road, it is not.
It's a complete
it is not
misunderstanding of what the purpose is, please.
No, my Lord, that is, Your Lordship may kindly see
Your
for
Lordship will see
development.
the local residents.
I'm sorry. This is not the correct way of understanding this at all.
My Lord, Your Lordship.
Only the road is being expanded.
Your Lordship can pass the order. I am not standing on the way. But one thing, I have made two queries that is to be answered.
The queries will not arise because it is a wrong. See, if you ask a wrong question, you're bound to get a wrong reply.
Then Your Lordship may note down my query and Your Lordship may pass the order.
All right.
I have nothing to say.
All right.
Yes,
All right.
that Your Lordship may do.
All right. You say the apprehension expressed in this petition by an old
And
students
another thing,
association.
Your Lordship may pardon me, another thing, NCP report says every 10 minutes there is a rape in the country, in the Odisha also.
Sorry?
National Crime Bureau report says there is every 10 minutes or half an hour, there is a rape case. They are unable to give protection to the women at large. So the distance from the college, the inmates of the college, those who are in sports, they have to run 3 to 4
There is
kilometers.
an expansion of the playground. I don't know what you're trying to say.
That is not the expansion.
You're refusing to answer when you keep on saying it is not so, it is not so. We keep asking you. When they have specifically said that the area of the playground is going to increase,
my Lord, that is,
you're not able to answer.
My Lord, my answer is they have taken out 557 AC 0.557 decimals of land from the college. Your Lordship, 557 decimals of land from the college. That is their affidavit. Yes. And in lieu thereof, what they have stated, in lieu thereof, they have stated that they have in a corner, our playground will be enhanced.
By the adjoining plot.
Yes, adjoining plot.
47.
What is that plot, my Lord?
47.
47 is the extent of land is 3.450. Yes. And 3.45, my Lord, that is our land.
Your land, that is government land.
Government,
in fact, this is another, I think, complete misunderstanding of what this whole thing is.
Your Lordship may pass order.
Yes.
Because
the apprehension expressed by the
all government land, my Lord, that
petitioner,
is
which is
my
an
problem.
old student association
that is my
of
argument.
the Shailabala Women's Autonomous College, Cuttack, is that one portion of the playground of the college is being utilized for the Chandi Mandir beautification project. Yes. And that this is likely to affect the adversely affect the students of the college. But depriving them of the facility of the playground. Full stop. This court had, by its order dated 2nd June 2022, required the collector Cuttack to file a detailed affidavit on two aspects. 1, whether in order to materialize Chandi Mandir beautification project, any land of the college is likely to be utilized, ? And if so, what? And if so, 2, what provision has been made for giving suitable land / facility to the college in lieu of such land likely to be utilized for the project keeping in view the interests of the college and the students? Question mark. Paragraph. Pursuant to the above order, on 13 July 2022, the collector Cuttack has filed a detailed affidavit. In answer to question 1, it has been stated that the playground of the college is partly covered by plot number 45 under Rakhit Khata 674, which is a governed land. Full stop. The copy of the record of rights bracket ROR has been enclosed as annexure A4. Full stop. The total area of the government plot is AC 3.450 decimal. Full stop. In annexure C/4, which is a sketch map, it is indicated that out of this government plot number 45, an area of only AC 0.557 decimal out of the total area of the said plot is being used for, open quotation, shifting of the public road, unquote, so as to create space for parking for the devotees visiting the Chandi temple. So in other words, this portion of the land is being used only for expansion of the road. Full stop. To compensate for the loss of the above extent of land of the playground, it has been decided that the existing playground will be merged with the adjoining plot 47 of an area of AC 1.871 decimal. Full stop. Thus, the playground of the college is actually going to increase from 3,900 square meter to 4,800 square meters. Full stop. Paragraph. As regards the question 2, it is stated that a project implementation committee has been constituted, which includes invitee members from the college. The said committee held its meeting on 17 June 2022, and the minutes of the meeting have been enclosed as annexure F/4. Among the proposals made at the meeting include renovation of the college, development work of the college in 2 phases at a sum of rupees 6.35 crores in the first phase and 80 lakhs and approximately rupees 80 lakhs in the second phase. Full stop. It is proposed that land admeasuring AC 5.000 decimal will be given to the college out of the reclaimed land for playground at Hadiyapata near the Mata Mata Square, which is within the CMC area at a distance of 2 to 3 kilometer distance from the college premises. Full stop. Paragraph. The net result is, apart from the existing playground increasing to 4,800 square meters, an additional space of 5 acres for another playground is being proposed at a distance of 2 to 3 kilometers from the college. Paragraph. Ms. Sujata Jaina, learned counsel for the petitioner, insists that the questions raised in the present petition about the secular nature of the college being affected and there being an infringement of Articles 46 and 49 of the Constitution, including Articles 15, 16, 26, and 29 of the Constitution, appear to this court to be misplaced. Full stop. No part of the land of the college is being used as such for any religious purpose. Full stop. It is only being used for expansion of a public road. Full stop. Further, it is plain that the facilities of the existing facilities of a playground for the college is in fact being increased and not diminished. Full stop. Consequently, the court finds the apprehensions expressed in the petition to be unfounded. Full stop. The petition is accordingly dismissed.
My lord, urgent copy of the lordship's order.
Yes, yes. An urgent copy of this order be provided as per the rules.
Supplementary list for hearing item number 23. But in this case, your lordship, my lords, made order dated 15/7/15 has admitted two questions, my lords, and those two questions had question number 1 and 2 is identical to the judgment of your lordship, in which, my lords, your lordship have answered all these two questions, my lords. That is in the case of I have given a copy to your lordship, my lords, in Upahar Udyog case. The last occasion I have given a copy of judgment, my friend wanted to verify, and question number B and C of Upahar Udyog's judgment is identical to question number 1 and 2, which your lordship have formulated in this case.
Yes, Mr. Badi.
My lord, I have gone through, my lord. My lord, may kindly see. I believe these two questions have. My lord, kindly see the question here, my lord. Tribunal has upheld the assessment order. It has said the first appeal order. Question of enhancement, my lord, cross subjects or enhancement, nothing of that sort, my lord.
If my friend wants me to explain, my lords, I am explaining, my lords. My lords may kindly see. First of all, question number 1 and 2, and those are identical to question number B and C of the judgment. Now, explain the questions which I have formulated and also admitted, my lords, on 15/11/7/15, my lords, page 28 of the tribunal's order. Yeah, page 28.
We'll take it up tomorrow, sir.
My lord.
List tomorrow.
Supplementary list item 24.
24. This is for final hearing.
Item 24, my lord. I am appearing for the appellants in this case, my lord.
For hearing.
I pray 3 weeks time for hearing, my lord.
Sorry?
I pray for 3 weeks time, my lord.
No. We'll take it up Thursday. Listed on Thursday.
My lord, I am for appellant number 4. Appellant number 10. Except appellant number 10, all others are on bail. And besides, the conviction is taking aid of 149 or all the 15 appellants, they are convicted taking aid of 149.
Thursdays.
And most of the
item 25.
My lord, the item may be taken up next week.
This is the third time the department is taking adjournment. Lordship will see.
Anyway, today we can't hear it, sir.
No. I am not insisting upon. Because it's already 5 o'clock.
We are grateful to you for that.
My lords, a remarkable thing is that Lordship is sitting constantly 10:30 without being irritated. This is a remarkable thing and very rare in India.
All right.
My lords, what I pray, my lords, let them take time. My lords, why they are taking time? May I just say in one sentence?
Yes.
Your Lordship raised a query as to whether the department has filed any appeal against the ITA by the Kotak Tribunal in ITA 69 and 70.
Correct.
And now they are going on verifying, my lords, and at least 4 months have lapsed and they are still verifying.
All right.
And the tribunal in 22, tribunal's order by, just I will invite your lordship's kind attention, kindly bear with me for a minute. Page 35 of the tribunal order of the brief filed by the department, para 22. Identical issue was raised in SSC's own case before the tribunal in ITA number 6970
for the assessment year so and so, and has been decided in favor of the assessee by holding by the coordinate bench, financing or aiding or assisting any promotional activities of the industrial undertaking is part of the business of the assessing company.
All right.
So whether that
The
is
last
business,
opportunity is granted to counsel for the revenue to ascertain if an appeal is filed by the revenue against the earlier assessment orders involving the same issue. It is made clear that no further adjournment will be granted on the scope.
can it be next Thursday, my lords?
You're really putting this pressure on them. 4th August, sir. Oh, sorry, 3rd August. 3rd August.
3rd August, my
All right.
3rd August, my sister will not be there. So
all right. 24th August.
24th.
August 24th. 10. Sorry.
Thank you, my lords.
No, please.
Item 10.
Sorry, Mr. Saring. I thought we could come back to this. So we'll have it on some other day.
My lord.
Yes, ma'am.
We'll have it on 27th September. Sir. All right.